is your lordship. Lordship, with respect to item number 15, it is come for orders, lordship.
Huh?
With respect to item number 15, lordship. Lordship, we were supposed to file a Dasti affidavit on or before today, lordship. We are filing it during the course of the day. Lordship, may kindly adjourn the matter for the day.
Item number 15, what do you want?
Lordship, we are filing the Dasti affidavit during the course of the day. For the last order, we were supposed to file on or before today, lordship. So lordship, may kindly adjourn the matter for the day, lordship. Service has not been completed by other.
Then the service is not complete, so I have to fix another date.
And we are going to file a
Fresh Dusty. Do you know the Dusty is a date fixed?
Right.
So if you have not filed the affidavit and I don't take it up today, that means the service cannot be deemed to be complete. So it has to be fixed another date, on which date you have to take a fresh Dusty. Which do you want?
Lordship will take a fresh dust. Lordship, let the matter come up. Lordship may fix a date, lordship.
Huh?
Lordship will file the dusty today. Then lordship may fix up the matter on another day. Fix the matter on another day.
Interim order?
There is no interim.
Okay, let it come after vacation. It has been submitted that the Dusty service has, it is seen that the application and the Dusty service have not yet been effected, as the affidavit for Dusty has not yet been filed. Considering the above, the matter stands adjourned to be listed after vacations.
Right.
I'll go interim order night. The interim order, interim order. Yes.
Ship, my senior is out of station. So due to passing of his younger sister. So maybe take them after vacation.
What are you challenging?
Ship, initially a money suit was filed. After that, when the dependents appeared, they filed in a Section 8 arbitration application. Subsequently, we filed our objection, but the money suit was dismissed and Section 8 petition was allowed. But Lordship, we are challenging that impute order in dismissing the money suit. Because Lordship, there were two agreements and as per the agreement made on 5/11/14, Lordship, there is a provision for
Where is the agreement?
along with the claim. Lordship, page 29. Lordship, also the amount is not disputed. It is an acknowledged amount.
Then? Page?
29.
Where is the?
Lordship, in 29, the provision number 3, in default of the payment of the dues, the second party may initiate appropriate civil and criminal action against the first party.
So where is the agreement? Wherein the arbitration clause is there?
Page 41.
Clause 25. Notice making it returnable on 11th of August 2025. Steps be taken upon the respondent numbers 1, 2, 3, 4 by way of registered as well as usual. You don't have any urgency. You have an urgency. I'll give you the liberty to take steps by Dusty.
We will take that.
Dusty, because your suit has been dismissed, no? Steps be taken. With a Miss So-and-so appearing on behalf of the petitioners, submit that there is an urgency, taking into account that the suit of the plaintiff had been dismissed. Accordingly, liberty is given to effect service upon the respondents numbers 1 to 4 by way of Dusty routed to the registry of this court and file an affidavit of service on or before the next date. The petitioners herein have assailed the order dated 13/10/2023. Why are you challenging this order now? You have to file 115. This is not 227. How do you file 227 here? 115, then there is a delay. Delay petition. Huh? Delay condemned. This is an application. The petitioner have assailed the order dated 13/10/2023. Passed in Mize case number 801/2017, arising out of money suit number 160/2017, whereby the suit filed by the petitioners as plaintiff was dismissed on the ground of on the ground of section 8, on the ground that the dispute is covered by an arbitration clause. The learned counsel appearing on behalf of the petitioner submitted that the learned court of the civil judge number 3 Kamrup Metro at Guwahati had committed an error in exercise of jurisdiction in as much as the dispute which arose was not in relation to the agreement dated 2010/11/2009, but rather on the ground of breach of the agreement dated 5/11/2014, which did not contain an arbitration clause. The learned counsel therefore submitted that the impugned order is required to be interfered with. Taking into account the above, this court shall pass appropriate orders upon service being effected upon the respondent. List accordingly. Yes, what is this?
Okay, I am agreed by the order passed by the Learned Court of Trial on 11/4/2025, whereby the entire suit was decided on merit, and earlier it was dismissed by the Learned Trial Court, was again decreed by the Learned Trial Court after being remanded back by the Learned First Appellate Court.
Wait. What happened?
The plaintiff I am the defendant in the main suit. The plaintiff filed a suit for declaration of right, title, interest, and recovery of possession. So the main contention of this plaintiff was that he purchased a particular plot of land by way of a registered sale deed. And another contention was that we have encroached upon the land and we filed a petition under section 145, 146 before the authority and attached that land. On that basis, they filed a suit for recovery of possession and declaration of right and interest.
2 suits.
One suit.
Okay.
The suit of the plaintiff was dismissed, holding that the plaintiff has failed to prove their case and the land mentioned in the 145 proceeding and the land mentioned in the schedule of the plain are completely different and distinct. The plaintiff did not come before the court to adduce evidence. So overall, the suit was dismissed by the learned trial court, holding that the plaintiff has failed to prove the case. Then the plaintiff filed an appeal. Appeal was also dismissed. Then the appellant plaintiff came before this honorable court by way of a regular second appeal. So while remanding back the regular second appeal, this honorable court held that the primary contention that the suit land is different from the suit land mentioned in the plaint of the suit, it is to be determined, and the learned first appellate court failed to exercise its jurisdiction as conferred upon under order 41 rule 31. So due to that reason, the suit appeal was this appellate judgment was set aside and it was remanded back to the learned first appellate. Now, the learned first appellate court, what the learned first appellate court did, without formulating any question, without formulating any point for determination, straightaway remanded back the matter to the learned trial court under order 41 to 25 by framing an additional issue as to whether the land mentioned in the 145, 146 proceeding are different or the same land as it mentioned in the suit. So the learned trial court, after being remanded, because this appeal was disposed of after remand,
Well, it cannot be disposed of.
cannot be disposed of. That's
Then?
what matter. I am challenging that order also. That order was passed way back in the year 2018. So where under the impression that the learned trial court would decide the additional issue and will return the finding to the learned first appellate court as envisaged in order 41 to 25.
So you cannot challenge order 41 rule 25 here. The remand which has been made, you cannot challenge by way of this petition, taking into account your provision of order 43 rule 1U,
It says about order 23A and order 23.
25.
23. 25 is not there. Order 43, order 41 rule 23 says if the suit is disposed of on preliminary, appeal is disposed of on preliminary ground and remanded back. And order 43 rule 1U, it says about an order of remand under rule 23 or order 41 remanding a case.
So 41 it will come in. Then
The subsequent order passed by the learned trial court.
but if you have not challenged that order, you cannot challenge it this way. So if you have not challenged that order, then the question is, he framed an additional issue and sent it back. Then he decided it.
The entire suit whereby the entire findings were reversed.
So if that be so, then you have to again come and file a first appeal. Isn't it a decree?
It is a decree, but.
Then how do I do anything
But
here?
my contention before this honorable court is that whether the same court can reverse its finding when the judgment and decree was not set aside by the learned first appellate court. Because by the order of remand, the judgment and decree passed by the learned trial court was not set aside. So I am challenging the jurisdiction.
Let us
of the-
see the judgment passed by that court. Where is that? Appellate court's remand order?
Remand order, your lordship will find at page.
Both
27.
parties are present through the council. On the last date, I've heard that the judgment is appended in CR sheets in separate, my discussion in here. And he is remanded back to this court for granting opportunity to lead evidence by following on the following new issue. Issue number 7.
Page
And
29.
direct the survey commission and send a copy. This is the appellate court judgment.
Yes, page 29.
Therefore, it is to remand this case, we are for giving opportunity. Why you are saying it is to be under order 41 rule 25
Because an additional
and
issue-
then pass a fresh judgment to the suit? See,
Yes, it is written,
then
But
fresh
the-
judgment.
but the trial court judgment was not set aside. The earlier judgment and
Aha, there are many judgments on that. Don't worry. That I'll take care of it. Many judgments where it says that when the court remands it, unless specifically does not say that it is kept in, then it is goes for a 6. The judgment has already gone.
but
You
the
need,
earlier
I can give
direction,
you 4, 5 judgments on that.
but earlier direction passed by the so determine the appeal in view of order 41 rule 31. It was not decided on that background.
First of all, why will I interfere with this order?
Because the additional
This
issue was
order has been passed in 2018. In 2025, why will I do that?
culminates into a judgment, a fresh judgment and decree which has come.
That
against-
was a direction passed by the appellate court
Yes.
to then pass a fresh judgment on the suit.
The additional issue can be framed under order 41 rule 25. Order 41 rule 25 is that after the finding is recorded by the trial court, it has to be returned back to the first appellate court to decide. Because my appeal was.
You see, when it is done under order 41 rule 25, it is, issue is being framed and then remanded and asking the court only to give that findings
Yes.
back and thereby keeping everything intact. But in this case, the court remanded it by framing an additional issue, say that decide this issue and pass a fresh judgment. Now, this order has not been assailed. You should have assailed it under order 43, rule 1U.
But right, said that he was under the impression, because he argued in fact before the learned first
He
appellate
has
court.
been an impression, but page 34, then pass a fresh judgment.
Yes, it was a wrong interpretation that he came into by the learned.
This you cannot help it. Secondly, this is a judgment, you file an appeal there.
Appeal also, when the main suit, the judgment and decree, which was dismissed earlier, now it has been decreed. Now the same court has reversed the finding of the same, finding by the same court. But this is one of the jurisdictional error matter, that's why 227 article. Because this, whether the same court can reverse its
Do
own
you
finding.
want the dismissal on merits or withdrawal? Which one? If you want, I can pass an order, dismissal on merits without even giving you anything.
I may be allowed to. I may be allowed to.
Withdraw. Mr. S. Biswas, the learned counsel appearing on behalf of the petitioner, submits that he may be permitted to withdraw the instant petition and without affecting his rights to prefer an appeal against the judgment and decree dated
11/4/2025.
Eleven 2025 before the appropriate first appellate court passed in 11/4/2025 in title suit number 28/1997 before the appropriate first appellate court. Taking into account the above, the instant application stands closed on withdrawal with liberty, withdrawal, comma, the withdrawal of the instant petition shall not prejudice the petitioner. The period. When did you file? The period from
We filed on
26,
26/2025.
2025 till date be excluded while computing the period of limitation.
Much obliged.
Repeated prayer to dispose of the injunction petition. My lord, the facts of the case is that, my lord, petitioner responded with a never. Now, we have a long, my lord, revenge. Afterward, my lord, now we are carrying out construction and their objection is that now we have enclosed their part of land, my lord. Based on that, my lord, they have approached before the trial court below. The trial court, my lord, initially declined to pass any additive injunction against which appeal was preferred. And in appeal, my lord, there is a direction that contained in page 85, my lord, 86, my lord, that we should not encroach their part of land and apart from, my lord, the construction.
Why are you challenging this here?
My lord,
Why are you challenging?
my challenge that, my lord, the injunction which has been passed right now, my lord, if suppose we go to the maid, my lord, that side will come, but question is that, my lord, So for the trial court injunctions, my limited page date, the next date is 4/8/2025, my lord. Well, the attempt may be made to dispose of, my lord. In between, my lord, will not, my lord, touch their part of the, even we have not touched, my lord.
No, understood. This you got the injunction. Why didn't you, did you file your written objection?
No, my lord, because the next date is 4/8, my lord.
The next date was 24/6.
The 26th, we have short time because on that day we enter the appearances and short time, the next day. is
You
4/8.
could have the air to file this one, the entire petition, but you couldn't have the air to file a written
My lord,
objection in an
objection, my
appeal.
lord. We have received, my lord, afterwards that brief, my lord.
Which one? Withdraw or dismiss?
Regarding maintainability of the petition,
My lord.
Withdraw or dismiss? Which one?
Then, my lord, no option left except withdraw, my lord.
No, withdraw, better.
But lordship, may only,
I give you the liberty to file,
yes,
file
my
the
lord, on
written
observation.
objection there
Yes,
and request the court to,
yes,
when you are going to file your written
my
objection.
lord, within next week, my lord.
Okay, then I'll fix a date there,
4/8 is the
on
next
which
date, my lord.
date the court will
Yes.
fix a date for
That
hearing
is
of
my
the.
prayer, my lord.
my limited prayer,
You cannot have a limited prayer. You have got an injunction?
the dispute.
No, no, Mr.
Yes,
Sharma,
yes,
you
yes,
have got
yes.
an injunction?
Yes, sir.
Okay. I'm not interfering with the
Yes, ma'am.
injunction. The date has been fixed at 4/8. He says that within 1 week he is going to file his written objection.
Yes.
Before trial.
Before that court,
Trial
this
court,
court,
right.
whichever court it is, this misappeal.
This was
My misappeal, my lord, that
Civil
appeal
judge
is
number
8/9,
one.
my lord. Because, my lord, misappeal, lordship, suppose close for a moment. Because injunction will continue, my lord, there is no any problem, my lord. Next date is 4/8, on that date, my lord, matter may be disposed of. My lord, prior date will file objection.
No, no, no. When are you going to, we are concerned with 23/5.
That's 23, my lord.
This is in misappeal.
My lord, misappeal, lordship, that's what I'm saying, my lord, misappeal, other delay again, delay, my lord. The appeal is, the next date is, my lord, 8/9, my lord. Appeal. And trial court date is 4/8 for my lord, objection and my lord hearing.
No, 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 no. What are you challenging before this court?
Appeal, my lord, appellate order, no doubt, my lord.
So therefore, you are to, there is an injunction given in the appellate order.
Well.
So you have to file your objection
Yes.
there. So
No
this is fixed on 8/9.
8/9,
So instead of 8/9, he is going to file within 1 week.
yes, ma'am.
And both the parties will fix a date on which he is filing. Then in the presence of both the parties,
Yes,
the
ma'am.
court will
Yes,
fix
quite
a
right.
date
Yes,
and dispose
yes,
it off.
no problem.
That's all.
And otherwise, my lord, only second option which I am, my lord, proposing, my lord, that suppose injunction will continue, my lord, there is no problem because they are ultimately getting in additive injunction, we are not opposing, my lord. Let it be continue. Prior to date, 4/8 is the date, my lord, for trial court, my lord.
Trial court,
On
I
that day, my
cannot
lord, file
touch
objection,
because you are only challenging this, Mr.
but
Counsel.
again, that will delay, my lord, unnecessary. The trial court the injunction petition will be delay, my lord, unnecessary.
Then you have to withdraw this appeal.
Then lordship will file objection in our appeal and lordship. will file.
Lordship, this is-
Trial court, what has happened? You didn't get an injunction. You got an injunction.
No, no, that has been declined, that's why appeal they preferred, injunction got in appeal, my lord.
You got
Trial
an
court
ad
refused to
interim
grant-
injunction.
Trial court refused to grant ad interim temporal injunction against that. We'll file the misappeal report of civil judge number 1 also.
Look, you mean to say ad interim injunction was not granted by the trial court.
court, yes,
So you filed an appeal.
yes, court.
And when you file an appeal, the
There
court
is an
granted
application.
an ad interim
Yes,
injunction. So that appeal is there.
Yes.
So therefore, there is one injunction application there. The
Yes.
second injunction application are before the appellate court.
Right.
And the third is before this court.
My humble submission is that the present order impugned is not a revisional one, Lordship. That's because the order impugned was passed in a application under order 39 rule 1 and 2. So my humble submission is that this is not a revision petition. It ought to have been appeal under order 43 rule 1 R. Lordship. That's because the order impugned was passed in a petition under order 39 rule 1 and 2.
So tomorrow, an appeal has been filed. I mean, just giving an example. Order 43 Rule 1R, an appeal is being filed for an injunction not being granted by the learned trial court. Okay. The first appellate court disposes the appeal and grants an injunction because in the appeal there cannot be a prayer.
Yes. Quite right.
Yes.
In an
Yes,
appeal,
yes,
is
yes,
there a
I
prayer?
got the point. Yes, I got the point.
Impliedly, my lord.
So
So you
once
go
appeal-
there,
Madam.
therefore I'm not interfering
No
with
problem,
anything.
no problem.
He is going to file within 7 days.
Fine.
I'll fix a date. on which date he is going to file his objection.
Correct.
And on that day, the court is going to fix a date for hearing and dispose of
Yes.
within 1 month.
Yes, yes.
What is, one submission also. While deciding the misappeal by the learned constitutional court, by invoking jurisdiction under order 39 rule 7 lawsuit, a commission, revenue commission may be issued.
Huh?
Revenue commission
Ah.
may be directed to be issued to the learned constitutional court.
Why?
Because there is dispute regarding the position of the,
Mr. Counsel, have you filed any order 39 rule 7?
that may be,
No, have you filed
No,
anything?
not filed.
Then why are you asking these type of things? I'm on a very limited score out here. If you want, I can do one thing, do one thing. You go out, let me stay this order, then you fight
No.
it out. No, we fight it out.
sorry, Lord.
No, unnecessarily don't make submissions before this court.
Oh, sorry, Lord.
I think better stay it.
Oh, sorry, Lord.
We'll see next time, we'll
Oh,
hear
so-
it
so-
next.
Sorry, Lord, sorry.
Mr. Heard Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner, and Mr. R. Sharma, who appears on behalf of the respondents on caveat. The present application has been filed invoking the supervisory jurisdiction of this court, challenging the order dated 23/5/2025, passed in Mize case number 479/2025, arising out of Miss Appeal number 11/2025. So, it is relevant to take note of that by the order dated 23/5/2025, the learned trial court, first appellate court, had fixed 24/6/2025 for SR/appearance in the said injunction application, and further restrained the petitioners herein from carrying out further construction towards the side of the petitioner's land till the next date. First, this court had put a pointed query upon Mr. S. Samaria, the learned counsel, as to why no objection was filed to the said injunction application before the appellate court rather than approaching this court. That too after 24/6, that too. Approaching this court. Full stop. He submits that the next date has been fixed on 8/9/2025. This court further inquired as to within how much time the petitioner would be in a position for filing their application, filing their objection to the said injunction application filed before the appellate court. The learned counsel submitted that within 7 days he can file, and further submitted that the direction may be issued to the learned first appellate court to dispose of the said injunction application upon filing within 30 days, taking into account the provisions of Order 39 Rule 3A of the Code of Civil Procedure 1908. Full stop. The submission so made in the opinion of this court is a reasonable submission. Full stop. Taking into account the above, the instant proceeding stands disposed of with the following observations and directions. Full stop. Number one, this court had not interfered with the order dated 23/5/2025, passed in Mize case number 479/2025, arising out of Miss Appeal number 11/2025. Number two, the petitioner herein would file their written objection in Mize case number 479/2025 by 4th of July, on 4th of July 2025. Full stop. Both the parties are directed to appear before the learned first appellate court, that is the Court of the Civil Judge Senior Division number 1, Kamrup Metro at Guwahati, on 4/7/2025. Full stop. The learned, number 3, the learned first appellate court, that is the Court of the so-and-so, the learned first appellate court shall on that date fix a date for hearing of Miss J case number 479/2025. And thereupon, take appropriate, thereupon dispose of the same, preferably within 1 month from the date of appearance, so fixed herein above. Full stop. Number 5. The learned trial court, first appellate court also shall bear in mind that there is another injunction application proceedings which is still pending before the learned trial court while disposing of the said application. And they appeal. None appears on behalf of the petitioner on call. Full stop. List this matter after vacations.
The last petition is to.
We'll take it up with that, those matters are there, na?
Yes, ma'am.
We'll take up these matters with item number
9, 20 and 21.
20 and 21. This one,
Yes, my lord.
you have sent it.
Yes,
Where's
it
Mr. B. Gogoi? Where is the finance? Where is the JR? Judicial Department. Who is paying for the judicial department? P.R. Gogoi, where is Mr. Dinath? Call him. Mr. Gogoi, have you received this?
My lord, that. I will have to-
All other things have been done.
Otherwise, my lord, I have gone through it. Only my lord, lordship has only streamlined the lines, my lord. Not the new thing has been added. It was ambiguous, little bit now is very clear.
Now, the only thing that all other things have been duly accepted. The only thing is, it has been mentioned that except as provided in these rules, all other matters relating to pay, allowances, leave, pension, discipline, superannuation, and all other conditions shall be regulated by the rules of the state government for its employees or as recommended by the SETI Commission as applicable and accepted by the government of Assam with the concurrence. So I don't think this should have any problem because what you put it out there is that as may be regulated by the state government. That would have a lot of implications. So when do we get a better final result?
Yes, my lord, immediately on the new.
And where is that no judicial department? Chalo, none appears on behalf.
I can appear, my lord, I will convey, my lord, regarding this.
Mr. H.K. Das, the learned counsel appearing on behalf of the petitioner, submits on behalf of the Guwahati High Court had submitted that in respect to that pursuant to the communication dated sent to the Finance Department's approval, as well as the communication dated 10/6/2025, kept on record with and marked with the letter Z and Z1, comma. The Guwahati High Court on the administrative side had accepted the six of the seven suggestions so made. And specifically, the suggestions made at serial number 1 to 5 and 7. However, as regards the suggestion made at serial number 6, which relates to Rule 22, comma, in order to have a better clarity, comma, there is a modification have been suggested. Mr. B. Gogoi, the learned counsel submits that from a perusal of the said communication, which had been sent by the Guwahati High Court to the LR and Secretary to the Government of Assam Judicial Department, it appears that all the suggestions so made by the Finance Department have been duly accepted, except there is some modification to Rule 22 suggested. Gustav. He submitted that the said aspect would be clarified by the Finance Department on or before the before the next date so fixed by the court. Gustav. He further submits that he also appears on behalf of the Judicial Department, apart from the Finance Department, and submits that due action thereupon will be taken. Gustav. List this matter again on 17th of July 2025. The communication dated 21/6/2025, placed by Mr. H.K. Das, is kept on record and marked with the letter Z2. By end of July, the rules should come. Then, Mr. Gogoi, all this matter will then go to the division bench. Challenge to the rules if they have any. So it is outside my domain. Yes, what is this?
This is in respect of the promotion of the stenographer where they are seeking refixation of the ratio.
What?
There was a ratio that if I take my lots to the calculations,
Affidavit in opposition filed.
we have to file a reply.
Then file a reply. Mr. H. Patella, the London Council submits that the petitioner would file a reply to the affidavit in opposition. It is seen that the affidavit in opposition was filed on 17/3/2025, considering the above, list this matter on 24th of July 2025, This is the last chance granted to the petitioners to file their reply. Much of it.
Has to be tagged, my lord, along with those association matter.
What?
This
One court masters, they are seeking some pay parity with the solicitors and the head assistant of So it can be perhaps clubbed with that the matter relating to the Bharatiya Employees Association, where the 2013 rule is now under consideration before the court.
No, that is a
That
different
committee-
thing.
Because
But another thing I say, the court masters are asking for pay parity.
there is-
Now, this is to be done by the Chief Justice.
Otherwise, yes.
Have you seen my judgment, that order pass? No? এটা order এটা ওলাই দিয়কচোন, এইটো কালি এইটো নে পৰহি এইটো আপলোড কৰিছো। যেনে আহিছে। Now here what has happened, where is it? Other side not there. Mr. Gogoi, what I have done,
Pilot.
though I have allowed all the prayers made in the petition. There were two prayers. One is financial crunch that setting aside of 3/8/2022, as well as also for again discussion, the second.
Right.
So both the prayers have been allowed. I have set aside 3/8/2022 because of holding it that financial crunch cannot be reason. The question arises for some other better reasons out there, as could be seen. But what has happened is, in my opinion, I don't know why this has not happened all this while. Sometime around 2013, there is a shift. 2001 to there is, after 1989, in 2001 to there is a decision committees formed for having a uniform pay for all the seven courts then, for all the seven courts. And accordingly, then Justice Gogoi and Justice P.G. Agarwal were given out there. And they have given a suggestion, and then there is a draft rule prepared, everything is being done. Then what had happened, the petitioner association there was the only one who was active. And the courts, I mean, on the High Court, on the administrative side, completely forgot about what is going to happen to them.
At that time, my lord, probably they have got the central pay scale and they get.
No. Whether it is central pay scale or any pay scale, that is immaterial question. Because of the fact the Constitution only empowers the Chief Justice of the Supreme Court and the High Court, for the Supreme Court employees and the High Court employees. Therefore, the pay commission rules does not apply to the High Court. All these things do not apply. So, like just now, this 22, which we have asked to change in the subordinate judiciary thing. Here, the leave rules, the pension rules, all these things have to be made by the Chief Justice. And thereby, if you are allowing the state to do it or the center to do it, means you are giving up your right or your power, which is solely conferred upon you by the Constitution, to others. It is in fact a violation. It is contrary to the Constitution, because the Constitution only gives the power to the Chief Justice.
It can go against the basic structure of the.
It goes against the very basic structure. And therefore, in my judgment, I have also mentioned that how can you have that you are only for leave? So therefore, you need to have a leave rules. Yes, in the leave, because otherwise the disparity amongst all the courts will always be. So therefore, I have asked the petitioner to make those people party also. Because there also has to be, the state governments also have to be asked.
Yes.
Because after all, the High Court is a different institution itself. You cannot have anything to do with even the subordinate judiciary or the secretariat or anything. It is absolutely different. You cannot have the same ball game for this. So this is my, therefore I say that you have to have a separate rules for everything. All conditions of service. Tomorrow you may be then asking him, okay, why not here? Why should we have the framing the rules of 1967? Let the state government do, or the state government's rules which is there, let it apply. For the subordinate judiciary, it can, because of the fact that 309 and 234 gives the governor has the power. But here the governor doesn't have the power for these pay rules. It is the chief justice who has to there. So there is no question of gazette notification also. No. Although the High Court rule says that it will apply from gazette notification in 1.3 say, it is absolutely wrong. Because the gazette notification does not arise. And if you are having a gazette notification, you cannot have amendment by way of gazette notification. That and if it is not gazetted, the amendment is useless. You say? Don't give it. Don't give it. Don't give it. Yeah. So this is one aspect. The second aspect out here is how do you have a parity? Now, halke hona nahi. It's okay, man. How do you have a parity from here with the subordinate judiciary? Mr. Burwa, how do you have a parity? You cannot have a parity. They may get more, they may get less. All these things is absolutely the domain of the Chief Justice. Right. Therefore, in that judgment, these people can't get you a fee. You have the, do you have the, what you call, your net, these iPads? Yes. Kindly give it to them. Soft copy to tap put in. Soft copy to. Now, in this judgment of State of Maharashtra versus Association of Port Stenos, the Supreme Court deals with and says a very interesting aspect that in respect to the power under 226, because what this court will be doing it, the moment I interfere here on the basis of equal pay,
Yes.
I'm interfering with the power under 229. That is at page 36, you will get it. I guess.
There are 25.
There are 25. Finally, see there. No, page 37.
It's 37, second pack.
After the underlined portion, in view of the aforesaid judgment of this court, it is difficult for us to sustain the impugned judgment, wherein the High Court, in exercise of its jurisdiction under 226, has issued a mandamus directing a particular pay scale to be given to the court stenographer so-and-so attached to the IMA. In so-and-so, this court no doubt had issued certain directions ameliorating the service conditions of the presiding officers of the subordinate courts and also dealt with the appropriate pay scales for them, but ultimately did not propose finally examining the propriety of the pay scale or nor directed any particular pay scale should be fixed. It is no doubt true that the doctrine of equal pay is an equitable, but it would not be appropriate for the High Court in exercise of its discretionary jurisdiction to examine the nature of the work discharged by the staff attached to the honorable judges and direct a grant of a particular pay scale to such employees as that would be a matter for the learned Chief Justice within his jurisdiction under 229 to consider. So without a consideration by the Chief Justice in that regard, how can I exercise 226?
That would be a condition precedent to examine whether the duties are superior to that being performed by the lower court employees, thereafter fix the pays.
No, there is another thing,
Even on the issue of pay parity.
for the subordinate judiciary, there is already a recommendation by the Shakti Commission first and second. So that has been taken care of by the Judicial Pay Commission. So
So therefore,
Therefore-
for them, it is another aspect.
another respect.
And therefore, those cases, all India judges cases comes into the
Exactly.
picture.
Exactly.
But for the High Court, unless you fix them, how they are now being given as per the ROP plus PSP,
Yes.
they are being given. Now their salary is less, may have been less with the Seristadar. Maybe there's no quarrel with that. But the fact that this is being done as per the ROP or applying equally what is there for them. But for them, the first duty is of the Chief Justice.
Yes. Yes. So call has to be taken by the chief.
First, and if the Chief Justice does not take a call, this court can ask the Chief Justice to do it.
But
Now,
that exercise.
How, but I cannot fix a pay, equal pay rate.
No,
This is the main problem. Normally, when it is between two high court, department and departments, I can very well say on equal pay or equal whatever. May be. But here it is very difficult for this court because of the
the soul is different, my
Mr. mm, thank you. Mr. Gogoi, kindly see paragraph 35 of the judgment. This court also cannot be unmindful of the fact that the jurisdiction under Article 226 in matters of the present nature is very limited. The jurisdiction so conferred in matters of the present kind has to be delicately balanced by keeping in mind the authority of the Chief Justice. Have you got it? Paragraph 35,
35,
page 46.
My lord.
The jurisdiction so conferred in matters of a present kind has to be delicately balanced by keeping in mind the authority of the Chief Justice under 2292 of the and equally the right of the state governments to have justifiable reasons. This court, therefore, is to point out the defects which have led to the declining of the approval and pass appropriate orders so that the High Court as well as the state governments can act together in making the rules governing the zones. So this is the jurisdiction in these type of matters.
My lord, may kindly dispose of this matter, granting us the liberty to approach the Honorable Chief Justice on the administrative side on the specific issue of delineation of our responsibilities and duties vis-a-vis the employees of the subordinate judiciary. And after finding.
No, you may have all these things.
Yes.
As regard the subordinate judiciary, whatever may be, you may have. But this matter with, that is why I have given, if you see this particular, this judgment, I have dealt with a very important thing here. Kindly see paragraph 26, page 38.
Yes. The distinctive nature and person, the distinctive nature and personality of the duties.
You have got the judgment?
I have the soft copy.
Okay, you also got it. The above deals with what the Chief Justice of the High Court is required to do while making the rules relating to fixation of salary and emoluments of the officers and servants of the High Court. The Chief Justice is required to consider the distinctive nature and personality of the employees of the High Court. The Chief Justice, as per the observation of the Supreme Court, is required to ascertain the job contents of various categories of employees and the nature of duties which are required to be performed by them. Further, the Chief Justice has also to take into consideration the representations and suggestions of the different categories of employees, keeping in view the financial capability of the state. In short, what the pay commissions under the central government or the state governments are required to take into consideration, the Chief Justice of the High Court is required to carry out a similar exercise insofar as the employees of the High Courts are concerned. It may be opposite to observe that the pay commissions, amongst others, are required to take into consideration factors which inflation, economic condition, the cost of living, prevailing market prices. All the above aspects, as stated, can only be taken into consideration by the Chief Justice of the High Court while fixing the pay and allowances of the employee. It is also pertinent to observe that insofar as the state government and central governments are concerned, periodical revisions have taken place in intervals of 10. The employees of the state governments and central governments have a right to submit representations as well as suggestions. And based on the representation and suggestion, the state government and as well as the central government make necessary changes, taking into account the grievances. For example, for the state of Assam, the Assam law was made on the basis was made applicable on the way of giving effect. On the basis of representation and suggestions submitted by the state government, employees modifications were made on the basis of the anomalies by the notification. However, in the case of the employees of EI, in view of where neither the Central Pay Commission nor the Central can decide on the entitlement or even take into account the representation or suggestion. This is so because the Constitution solely vests the authority insofar as the High Court is concerned upon the Chief Justice of the High Court, who would be required to form a special pay commission for the employees of EI. Similarly, the conditions relating to leave, pension allowances are required to be regulated only by the Chief Justice or his delegates by making appropriate rules. So this is what it is. I've also said 77 years have gone, but nothing is happening.
Perhaps, Milord, if this exercise happens, I think most of the problems will be solved once for all.
Because you need it. And it is, we are having a high court from 1948 and till now we don't have a pay rule. We don't have a leave rule. We don't have a pension rule. What is being done is, these have been extended.
Yes.
This is not how it is doing it. And therefore, all other high courts, only a few, Kerala has, Calcutta has, because if you see the judgment of Calcutta High Court, which Mr. Gogoi you have referred to, the second one, the rules have come in. They have the rules in 2007. Only it is the High Court, which this High Court is a very old High Court now. I think it's high time. Rajasthan and Guwahati High Court are similar. Both did their 75 years in 2023. They have their pay rules. Everybody has. The High Court doesn't have. Therefore, here I have also mentioned in my judgment, if you see this, what is the distinction of paragraph 23, if you look into it? Therefore, Mr. Bolwa, you need to submit a representation.
That
the
is there
Chief
at page 55.
Huh?
The representation which my lord is talking about, that is there page 55. Enter has structured my writ petition on this representation.
Page 55.
55 and extra 6.
This you have given to the Chief Justice.
Yes, my lord. This is-
What have they done?
They've done nothing else.
Yes, Mr. Das.
Yes.
This is the only issue here. page 55.
This has to be considered in lieu of the judgment by the honorable Chief Justice. This has to receive consideration.
Now with this judgment, Mr. Gogoi, a new avenue will be opening.
Not-
What was happening out there was all these old things.
Not-
Whether this amount is to be paid, that amount has to be
Yes,
paid. It was more like an upgradation and the petitioner association, they were expecting on that line. But I have strong reservations that unless you have the payrolls, how do you give it effective from there? That is the very difficult thing. But then also, at the end of the day, these four states should come together to, so that we have a rule. I have not stated that the state has, the court has to give this much, that is
Yes.
not my duty also. It is for the chief justice and the state to discuss and do.
Not.
Now, in this case, what to do?
But the moment the rules come, their issues will already be, will come under the same rule only. Whatever pay is fixed in the new rule, will have to be applicable to them. Today, we're not discussing whether they should get the same scale.
No, this is obviously, it is not possible.
Yeah, is the
I can dispose it of one thing, saying that in view of my order passing that
same
order,
committee may consider, my lord.
the registry shall place this representation before the chief justice. This will be considered then.
Yes.
Yes.
I think that is the best.
While
way.
framing the rules, it can be thought about.
Although
Yeah.
we not from the records of repetition, it reveals that their representation was forwarded to the judicial department. By the.
No, no,
So that is.
that is again a mistake.
Similar access.
No, the question of their representation being sent to the judicial department is
Not
also absolutely wrong.
Absolutely wrong. So,
It has to be done by the chief justice.
so it has to receive consideration by the honorable Chief Justice.
Once the chief justice says, yes, they are entitled to equal pay with them,
Correct.
then
It will
that
go.
will have to be then communicated to finance and judicial.
Correct.
But without that being done, why is the judicial department being brought into the picture?
It has happened again for the same reason that we don't have the rule.
No, no, therefore, the judgment which I have given,
It
I don't know if there is an appeal filed or anything, but this has brought a clarity
Correct.
as to what is the duty. They have, it is the duty of the chief justice. I also say one thing, that if the chief justice does not frame the rule, you see this paragraph, I made it very clear. Kindly come to 36. This court further finds it relevant to take note of the draft rules of Iman. The said draft rule only relate to the principal seat and not the outlying benches. It appears to be on account of a litigations filed by the petitioner hearing challenging the actions of the government of the state government of Assam. At the cost of repetition, it is observed that the Guwahati High Court is the High Court of 4 states. The Constitution provides that it is only the Chief Justice who has to frame the rules pertaining to the conditions of service of the employees of the High Court, and therefore the pay rules so drafted is required to be made in such a manner that it applies to the principal seat as well as the outlying belts, else may result in disparity amongst the employees. Additionally, confining the rules only to the principal and not having the rules applicable to the outlying may appear that the power under the Iman, which is specifically reserved only for the Chief Justice to exercise, is yielded to the state governments of Arunachal Pradesh, Mizoram, and Nagaland. Because you will be giving the power, okay, whatever you fix, that cannot happen. Heard Mr. Your doctor, Mr. N. Burwa, the learned counsel appearing on behalf of the petitioner, Mr. B. Gogoi, the learned standing counsel, Finance Department, Mr. H.K. Das, the Learned Standing Counsel, Guwahati High Court. The petitioners herein who are working as courtmasters,
Administrative officer, judicial and court master.
administrative officer, judicial and
Masters.
courtmasters. In the principal seat of the Guwahati High Court, had submitted a 6 parity in the pay scale with
Sheristadar and
the Sheristadar of the district courts oblique, comma, and superintendent's family courts.
head assistant. Head assistant.
Yeah.
Other is head assistant.
You are asking for parity with whom? Sheristadar,
And head assistant. Superintendents are also falling in the same category.
but you have given in the representation only this only.
Well, it's
They are asking
one
for area of Sheristadar in page 59
Sheristadar, yes. madam.
and superintendent.
Superintendent is also in the head assistant. They are now enjoying the same thing. So.
So therefore you are asking them, with them, parity with them,
Superintendent
na?
is also-
With Sheristadar in the district courts of Assam and the superintendent in the family courts. So in that regard, a representation was submitted on 7/2/2018 to the Honorable Chief Justice of the Guwahati High Court. However, as nothing has been done in that regard, the grievances of the petitioner remains unredressed, for which the petitioners have approached this court by filing the present writ petition. This court finds it relevant to take note of the judgment of the Supreme Court in the case of State of Maharashtra versus Association of Court Stenos, PA and PS, and another reported in 2002 482 SCC 141, wherein the Supreme Court made it very clear that the doctrine of equal pay for equal work is an equitable principle. But it would not be appropriate for the High Court in exercise of the discretionary jurisdiction under Article 226 to examine the nature of the work discharged by the staff attached to the honorable judges of the court and direct grant of a particular pay scale to such employees, as that would be a matter for the learned Chief Justice within his jurisdiction under Article 229 of the Constitution to do. It is seen that the representation in the backdrop of the above, it is relevant to take note of that the petitioners have duly submitted the representation before the Honorable Chief Justice. And Mr. H.K. Das, the Learned Standing Counsel of the Guwahati High Court, submits that the said representation have been forwarded to the Judicial Department. This court have also put a specific query upon Mr. H.K. Das, the Learned Standing Counsel, as to whether the Chief Justice have passed any decision on the representation as regards the pay scale, as to what should be the pay scale of the administrative officers and courtmasters, administrative officer, judicial, and the courtmasters of the court, to which he submitted that only the representation has been forwarded to the Judicial Department. During the course of the hearing, Mr. B. Gogoi had also referred to a recent order passed by this court dated 19/6/2025 in WPC number 2716/2023, wherein this court had passed necessary directions so that the employees of the Guwahati High Court, so that the Honorable Chief Justice of the Guwahati High Court can make rules insofar as pay, leave, pension, allowance, etc. in terms of it, in exercise of the power under 2292 of the Constitution. It is also seen from the said order dated 19/6/2025, so referred to, that an exercise is required to be carried out as regards the fixation of pay of the employees of the Guwahati High Court. Considering the above, by forming a committee by the Honorable Chief Justice, taking into account the above, this court directs the Registrar General of the Guwahati High Court to place this representation before the said committee to be formed by the Chief Justice in pursuance to the order, Honorable Chief Justice, pursuant to the order dated 19/6/2025 in WPC number so and so. And so that the said committee can consider the grievances of the petitioner. So with the above observations, the instant petition stands dismissed.
But there is another representation for the court master. There is 4th December 2017. This is for the administrative officers judicial, their cadre. So
There are two
two
representations.
representations. The next one,
Representations dated Edita Boradibo, huh? Where's the other one?
page 66.
Page
66.
66. One is that this one and the other is two representations. Wherein the AOJ is asking for similar with Seristadar District Court and Superintendent Family Court. And court masters are asking similar to the head assistant.
Yes.
সেইটো এনেকে লিখি দিব দেই। হ'ব নে? আৰু এইখন
Apply.
anything?
Already my lord concurred on my lord 17/6/2025. We have given that.
Mr. B. Gogoi, the learned counsel appearing on behalf of the finance department submits that the finance department had already given the concurrence in respect to the ex post facto approval towards engagement of the petitioner as officer on special duty with effect from 21/6/2021 to 26/2022. In that regard, the learned counsel has placed before this court a communication issued by the Undersecretary to the Government of Assam Finance EC Department, EC Roman 3 Department, along with the note issued to the Judicial Department. The same are kept on record and marked with the letter Z. Full stop. It has been submitted that Mr. H.K. Das, the learned counsel, submits that in pursuant to this concurrence being given by the finance department, the the High Court, the Guwahati High Court, would be releasing the dues to the petitioner. First, accordingly, list this matter on 14th of August 2025 for an update.
The printing mistake in my book, the order passed under order 41 on 25 is not applicable. Only the order passed under order 41 rule 23 and rule 23A is applicable.
Or
It was, it could be read as of 41. But the order passed under order 41, rule 25, is not applicable as per order 43 rule 1U. Only the order passed under order 43 rule 23 and 23A is applicable. So there is a printing mistake in my book, so I read it as or 41.
every book it is or.
I have checked in online also. It is written as of or 23 or 23A
My book also says or.
of 41. If I may read this, the sentence doesn't complete with or.
Hello, then you want the dismissal.
No, just I wanted to correct it that
We'll dismiss it. Don't worry. Let me come back. I'll dismiss that petition. then. No leave. Come back and dismiss it. I will file to the Mr. S. Viswastal and the council appearing on behalf of the petition. The petitioner herein have assailed, have invoked the supervisory. The instant a petition is taken up for disposal at the motion stage itself. The petitioner herein have assailed the judgment and decree dated 11/4/2025, passed by the learned court of the civil judge, Junior Division number 1, Hunitpur, in title suit number 28/1997, on the ground that the said judgment and decree is in contravention of the provisions of Order 41, Rule 25 of the Code of Civil Procedure 1908. First, the learned, in addition to that, the petitioner have also assailed the order dated 24/2018, passed by the learned court of the civil judge Punitpur, entitled Appeal number 5/2021, to be set aside,
2001.
2001, be set aside, and the learned first appellate court being directed to restore the title appeal, being title appeal number 5/2001, and pass appropriate orders in accordance with the provisions of Order 41, Rule 25 of the Code of Civil Procedure 1908. First, it is seen from the materials on record that where's the suit?
Well, it's suit, I have annexed the judgment and order of a decree passed by the Sonoma Court, RSA.
Who has filed the suit?
Page 20. My lord, the respondent herein filed the suit,
It is seen from the materials on record
page 21. RSA.
that the respondents herein, no, one, Prakash Bhagavati filed the suit. The respondent herein, as plaintiff, had filed the suit being title suit number 28/1997. claiming his right, title, and interest right over the land. Claiming his right, title, and interest over the suit land. As well as for consequential reliefs. The suit was dismissed by the learned court of the Civil Judge, Junior Division Number 1, Punitpur, by the judgment and decree dated 30/9/2000. Being aggrieved, the plaintiff preferred an appeal being titled Appeal Number 5/2001 before the court of the Civil Judge, Senior Division, Civil Judge, Punitpur. By the judgment and decree dated 13/12/2006. The appeal was dismissed, thereby confirming the judgment and decree passed by the learned trial court. The plaintiff oblique the respondent herein thereupon preferred a second appeal before this court, which was registered and numbered as 35/2007. This court by the judgment and decree dated 15/2/2017, by the order dated 15/2/2017, set aside the judgment and decree passed by the learned First Appellate Court on the ground of non-compliance to the provisions of Order 41, Rule 31. Full stop. Paragraph 17 and 18 of the order passed by this court in RSA number 35/2007 being relevant is reproduced herein under page 26 of the. From a perusal of the above quoted portion or quoted paragraphs, it would be seen that the coordinate bench of this court had set aside the judgment and decree passed by the learned First Appellate Court and remanded the same for passing a fresh judgment and decree within the parameters of Order 41, Rule 31 and 33 of the Code. In addition to that, there were specific directions issued to the learned First Appellate Court to dispose of the said matter after hearing the parties afresh, preferably within a period of 3 months from the date of receipt of the LCR. Thereupon, the record further reveals that thereupon the appeal was taken up for disposal. By the learned First Appellate Court. And by the judgment, by an order dated 2018, directed, remanded the suit back to the learned trial court to pass a fresh judgment in the suit in view of the new issue and additional evidence led. It is very relevant at this stage to take note of. That the learned First Appellate Court was of the opinion that from the materials on record, it transpired that the plaintiff purchased the suit land from Sri Phonidor Das and Tonkeso Das in 1996 by a registered sale deed and took possession. Further to that, from the records, from the evidence, the learned First Appellate Court came to a finding that subsequently the suit land was attached by the police and paddy was sold in auction based on a proceedings under section 145 and 146 of the CRPC, instituted by the defendant Phonidor Bora and the performer defendant numbers 2 and 3. And the plaintiff preferred a revision, and the learned session judge Honitpur set aside the order in a proceedings under section 145/146 of the CRPC. It was further observed by the learned trial court on the basis of the evidence that when the plaintiff went to plow the suit land, the defendant did not allow him to do so. And therefore, the suit was filed praying for declaration of the plaintiff's right, title, and interest over the suit land and for eviction of the defendant number 1 from the same. On the other hand, it was also the opinion of the learned trial court based on evidence that it was the case of the defendant that the suit land and the land attached under section 145 and 146 of the CRPC are not the same land. And therefore, taking into account the contrary stand taken by both the parties, the learned First Appellate Court was of the opinion that it was essential to determine whether the suit land and the land which was under consideration in the proceedings under section 145 and 146 CRPC are one and the same or not, and therefore framed a fresh issue to be issue number 7, which reads as under page 33. The learned First Appellate Court further was of the opinion that for proper adjudication, it is essential to remand back this case to the learned trial court to give opportunity to both the parties to lead evidence on the issue and to direct survey commission if required. Because the learned First Appellate Court further specifically directed the learned trial court to pass a fresh judgment in the suit in view of the new issue and additional evidence led. And the appeal was accordingly disposed of. In this context, the learned counsel appearing on behalf of the petitioner submitted that having framed a fresh issue and directed the learned trial court to adjudicate can only be done in exercise of the powers under Order 41, Rule 25 of the Code. And therefore, there was an error on the part of the learned First Appellate Court to remand the entire suit back to the learned trial court. Rather, the learned trial court, First Appellate Court, ought to have kept the appeal pending. And upon getting the said findings, decide the appeal on the basis of the findings arrived at by the learned trial court in respect to the issue number 7. First, in the opinion of this court, the said submission is misconceived, taking into account the observations so made by the learned First Appellate Court on the basis of the evidence as is reflected in paragraph number 6 of the order passed by the learned First Appellate Court. Further to that, it is a well-settled principle of law that the appeal is a continuation of the suit. And therefore, there is no bar on the part of the First Appellate Court to frame a fresh issue for deciding the appeal, fresh issue, and remanding the entire suit, and remanding the suit back to the learned trial court. This, it is further seen that the learned First Appellate Court had remanded the case back to the learned trial court and categorically observed that the learned trial court is required to pass a fresh judgment on the basis of the findings so arrived at in a fresh judgment in the suit in view of the new issue and additional evidence to be led. First,
materials are already there before the learned trial court, and they know new evidence was laid by both the parties before the trial court. The same evidences were taken into consideration, which was taken into consideration in the earlier suit. That is the PW1 cross-examination.
It is further relevant to take note of. The submission made by the learned counsel appearing on behalf of the petitioner. That the learned First Appellate Court, having not set aside the judgment and decree dated 39/2020, passed entitled suit number 28/1997, and have merely remanded the appeal back to the learned First Appellate Court. The learned First Appellate Court, the appeal would be deemed to be pending. In the opinion of this court, the said submission is misconceived and untenable. That too when the learned trial First Appellate Court categorically remanded back the appeal suit back to the learned trial court. And specifically directed to pass a fresh judgment. First, the order of remand so made in the present facts and circumstances would clearly show that the impugned judgment, the judgment dated 39/2000, the order of remand and thereupon a direction being issued for passing a fresh judgment, on the face of it would show that the impugned judgment and decree dated 39/2000, passed in title suit number 28/1997, was set aside and quashed, was set aside, was interfered with. First, under such circumstances, on merits, there is no question arises for interfering with the order dated 24/2018, passed in title appeal number 5/2001. First. Next. This court further finds it relevant to take note of that this order dated 24/2018 in title appeal number 5/2001 was passed first. There was no challenge to this order. At any point of time till filing of the present proceedings after 7 years. That too, when the petitioners herein have duly participated in the trial court, knowing fully well the judgment and the order dated 24/2018, passed in title appeal number 5/2001, directing the learned trial court to decide afresh the suit by passing a fresh judgment, by taking into account the additional issue and the evidence. On this aspect also, The question of interference with the order dated 24/2018 does not arise. Past entitled appeal number 5/2001 does not arise. First. Now let this court take into account the judgment passed by the judgment and order passed by the learned first appellate trial court, which have also been assailed before this court under Article 227 of the Constitution. This court finds it very relevant to take note of the judgment of the Supreme Court in the case of judgment Virat Mumbai wherein the Supreme Court categorically observed that when an appeal lies, when the Code of Civil Procedure have provided an appellate forum against a appellate forum, the question of exercising jurisdiction under Article 227 of the Constitution does not arise. In the instant case, the said judgment, paragraph so-and-so of the said judgment to us is quoted herein under. In the instant case, it would be seen that an appeal lies under section 96, read with order 41 of the code against the judgment and decree dated 11/4/2025, passed in title suit number 28/1997. First, taking into account the judgment passed by the Supreme Court as quoted herein above, the question of interfering with the impugned judgment on order decree dated 11/4/2025 in title suit number 28/1997 does not arise, for which the instant petition. Accordingly, the instant petition stands dismissed.
I accept to file affidavit. Look, in this matter, your lordship will remember, I was to have a meeting with the Registrar General with regard to equivalence of post of accountant and UDA. After that meeting, my lord, decision has been taken to place the matter before the rule committee. In the meantime, perhaps, my lord, the draft rule also will come into place, my lord.
No, we are concerned about that period then.
Yes, true, but
Draft rules, what do they say?
draft rule, the pay scale of UDA and accountant is identical in the draft rule. So I had a meeting with the Registrar General, we found that, and accordingly it was decided that the entire thing will be placed before the rule committee, because in the earlier matter, like LDA, copyist and typist and computer typist equivalence, the process followed was to route it through the rule committee, then issue a notification.
So a typist can become an UDA.
Yes, LDA, yes, my lord. It can become UDM.
As per the draft rules.
Yes, my lord. LDA, copies, typist, and computer typist. Because computer typist came in between. Earlier rule, it was not there. The post of
So
computer
they can become as
UDA.
per
UDA, as per
UDA.
the, as per draft rule.
Draft rule says about the promotional revenue will come from them.
Yes,
Because here we are concerned with whether
draft rule.
the post of head assistant,
Promotional
head
post of
assistant.
accountant and LDA, UDA, whether these two posts are equivalent for promotion to head assistant.
Therefore, the post of the head assistant is accountant
That's
and
what the,
accountant in UDA is the feeder category.
Yes,
Because as per the government, what they say, as per them, they even say that Nazir will also come in.
I don't think that will.
No,
Yeah.
because they say on the basis of the scale.
They said, but the.
Now,
pay
therefore,
scale-
my question here is, because if that be so, who are the people?
Then
In the same
Jarikar of
feeder
an-
would be the supervisory assistant, accountant, Nazir, upper division assistant.
Yes,
All come under the, would they come?
Same pay
Because
scale.
they are having the same pay with the great pay. Then? And this
So-
is the stand.
that cannot be the criteria in my humble subject.
Then, what is the criteria?
No, if equivalence is made on the basis of pay scale only, then there will be anomalous situation. So that's why, my lord, I had a talk with the Registrar General also. So that's why this decision was taken to place it before the rule committee. So what to do? Now, the designation of post in the draft rule are also different.
Hmm?
In the draft rule, if I just place, it is like
What is the promotional post? What are the feeder category for in the draft rules for head assistant?
uh, head assistant has been redesignated as head,
Huh?
head administrative officer of CGM or head administrative officer of district judge.
Now, what is the feeder post?
Head administrative officer of district judge, feeder post is administrative officer and bench assistant one.
So
now-
here also the accountant does not come.
No, here the problem is, although this draft rule not provides for this designation bench assistant one, we are still following the designations of the earlier rule, my lord. This is the draft rule, my lord. Now the draft rule is not applicable in our case.
Understood. I'm only getting an idea.
Exactly.
I'm therefore putting the question to him. That
So,
what
but-
is that? Because he's saying that let us await the draft rules. That can that be the reason why I'm asking? That is why I'm putting his question to. Because the High Court has not filed in spite of directions.
It's true, my lord, because before the RG, Registrar General, he cannot alone take this decision. Because this decision, earlier also similar decisions was taken by the rule committee. So.
No,
it was
Registrar
placed-
General cannot take the decision. It has to be taken by whom?
It will by the rule committee. It was
Why?
placed before the chief justice and
What is this rule committee's business?
not, a committee has been formed already in place.
Understood. Can the rule committee decide that?
Earlier, my lord, the rule committee, in the case of, my lord, LDA
It
copies,
has to be given by the full court.
yes, yes,
It cannot be by the rule committee.
that's true, my
The
lord.
rule committee's decision has to be placed before the full court. The full
Yes,
court
yes.
has to there because
Yes,
the,
we need-
it is the full court who has the power under 235. The
Correct.
chief justice has no business out there.
No, no. First rule committee, then it will be placed before the full court, my lord. First, it will be placed before the rule committee, then the final approval has to be by the full court, my lord.
So therefore, one thing is very clear that the High Court have not issued any instructions.
No. As of now, equivalence regarding no instruction.
So the appointment of any person, when there is nothing out there, isn't it contrary to the rules?
In that situation, the position, legal position as on date would be that whatever was the rule, that will have to
So
be
as
followed.
of now, we, as High Court, therefore it is your letter, whatever it is shows that the High Court is not clear.
Ah.
It's clear from there, because when you are referring to the rule committee, means
Correct.
the High Court is not clear.
Regarding equivalence, nothing is there.
The state government says that we have no business out there. High Court is the main person, but however, we say as per the scale, the UDA and accountant are one and the same. So they, however, could not answer the query which I made in paragraph number 4 of my order dated 29/5/2025, they could not. The answer is not there, for which I directed you are, the High Court is not clear. So therefore, the High Court does not have any administrative instructions.
As on date, Milord, there is no.
Obviously, not there. Otherwise, if it was there, you would have produced.
Correct.
So therefore, if they don't have, isn't it contrary to the rules to have the accountant?
Yes, ma'am.
Well, we decide,
If legal position,
legal question. we
ignoring
decide.
Milord equivalence and all
We
these
can't
things.
wait for the High Court to come up with all these things. They
Legal
don't file.
position, whatever.
They don't file, you do whatever maybe High Court appeal file. Yes, who is the one for accountant to become the district head assistant? Yours is accountant. You were the accountant. You have been deprived. Okay. So I dismiss his petition. And your case is? So we allow your petition. You are for accountant allowed. Yes, tell me, how do you now? Because I cannot decide in exercise of the judicial review, the equivalence of head assistant with accountant. No, equivalence with accountant with UDA. That is not my power. So therefore, you are to therefore say, when the rules do not prescribe the accountant to be the head assistant, to be in the feeder category of head assistant, how the accountant can be considered for promotion. Earlier done, that is illegal. I'm not on that. We are only on this.
All over Assam, by writing this letter, what is your opinion? What they should file by your affidavit, if necessary, will file this time, my lord.
No, they have filed their affidavit. They are not in a position to file. But as of now, one thing is very clear, that their district judge as well as the CGM, they are doing it on their own whims, without there being any backing.
Accountant is promoted from LD, my lord. Accountant is promoted from LD, UT is also promoted from LD. If the UT is qualified, then why not accountant is promoted? Accountant is senior to the person who has already made his head as my lord.
No, but Mr. Sharma, it is very difficult for this court to hold the equivalence, because it is not my duty to do it. The High Court have not done it. Now, without there being a representation from your side to the High Court to that effect, that kindly make all the accountants saying that we should also be made similar to UDA for the purpose of feeder category, how do I interfere? High Court doesn't know.
It should express their view, if necessary.
They are not expressing the view. They have placed it before the rulemaking committee.
10 to 12 years as UD. Accountant is equivalent to UD. 10 to 2 years, he was not promoted. They meant by relaxation only on completion of 5 years, he was promoted to head assistant. This is the, my lord, my submission, my lord, the court is not only court of law, it is a court of justice, equity and good conscience, my lord.
Now, I will interfere with him if the question is if there is any illegality. Don't worry on that. That I will interfere. But the question arises whether you have the locus.
Not if, that is when I am deprived, my lord.
You cannot be deprived because of the fact that you are not in the feeder category.
My lord,
Who has said that?
my lord. Not equal protection.
So first I have to hold, but
Okay,
Mr. Sharma, this court first has to hold that that particular post of accountant is equivalent to UDA. How do I hold it?
Then one accountant, my lord. It may not be, if they,
That is not your case, Mr. Sharma. That is not your case. That there should be an equivalence made for the accountant to be the head of UDA. That is not your case. What is your relief claim for?
I qualified, I am not given, I am not allowed to appear for the interview, my lord. That I am not
Rightly
qualified.
so.
I am face interview of that.
Mainly respond to cancel the appointment of the respondent and promote and appoint the petitioner to the post of ER with retrospective effect. That is obviously not possible.
Inequality, my lord. Inequality and injustice. I
You
am
should have asked for that. This is your relief which you should have sought for, that there is an equivalence between so and so. Then on the basis of equal pay, equal work, I can consider and pass some order on this. That is another aspect. But that is not the case out here. You are saying that your basic case out here is, look here, I am also appointed, promoted from the post of accountant from the LDA to as accountant, and he is also posted from LDA to accountant, head UDA. So therefore, I am equivalent to him and give it to me. I should be there.
not allow my petition, then it may be referred to the larger bench, my lord. I
Why?
request my vote.
Why?
It may be referred.
How do I refer it to a larger bench unless there is a single bench judgment which is contrary?
Express view that the accountant is not, accountant cannot be promoted to the head. It is not in the rule. It is not in the rule. That is why we have come for your lordship, my lord, that equal status. Both are
But where is your prayer for that, Mr. Counsel? Where is your relief being sought for to that extent that board should be given equivalence? There's no relief to the sort the effect. Yes, you submit now.
In relation to my.
You also come this side because both of you are in the same boat.
Yes,
Yes,
for item number 99, made the response.
okay, now you submit. How do I have the equivalence of both?
Initial appointment. I see appointment. One for the child, for that. His initial appointment was to LDA in the federal career of the post of head of the system. And subsequently, I was also appointed in the post of LD. So now, at the time of inception of our the service, we were equivalent. Now, in due course, 4 districts has been constituted and accountant post has been introduced. That is obtained by the notification. And that post is not differentiated, or it is not made not equivalent to the post of head assistant. Now from LDA to next higher post, the person has to be promoted, and that was accordingly promoted. You was also promoted, petitioner of item number 9. I was promoted to the post of accountant, which is
Why were you promoted to the post of accountant?
but
Show me your appointment. Where is your,
yes,
where is your appointment to the post of accountant? Let us see.
basic.
Where?
So for petitioner of item number 19, Deepak Kumar Sharma, he has stated that.
You have filed your
Yes.
affidavit?
Yes,
Yes, where is that?
pay annexer A, page 12 of my affidavit.
Annexure?
A. This is my initial appointment.
You are appearing in which case?
Item
662.
number 19,
662.
662.
That affidavit আছে নাকি sir? When did you file your affidavit?
It was filed on 29th of May 2024.
Huh?
29th May 2024.
There is no affidavit here. Anyway, show me a copy of it. You have got a copy. Show me why this is not here. This is LDA.
LDA, madam.
I'm
File
saying
is-
about appointment to, yeah, promoted to the
Madam,
vacant
next,
post.
next
to be-
page. Next. Accountant has been introduced in 4 districts. As per the notification number 31, 2007.
Then after your appointment,
Madam.
at page 13, on 9th of January 2020,
Madam.
you have then become, what is your name?
Saurabh Kumar,
Sutradhar. Then working as accountant in the office of the district and session judge has been transferred as bench assistant in the court of the extent demand in place of so and so. And is directed to hand over all the, so you don't remain the accountant any further.
should be done.
Again,
Posted in the post of my accountant. Last.
then again, you are now being made working as the bench assistant in the court of so and so is transferred to the court of so and so as bench assistant. Again,
Page 18.
page 17,
17 is the my Ben assistant.
bench assistant.
Next one.
Then again, what happens? He is so and so accountant is transferred to the accountant branch in place of
Pankaj Jyoti Thakuria, LDA. This is very much.
LDA. If you are transferred to to another post where which is now held by an LDA, then what happens?
So far, my look, posting a person to my look, accounts branch. Accounts branch has been my look, established not my look, only to for my look, preparing the bills and so far the accounts part is concerned. And so far, when the post of accountant is concerned, it is only introduced only in 4 districts, my.
Huh?
So, in 4 districts, my look, the post of accountant has been introduced by notification that 31/3/2007.
Where is that?
That is in the page 27 of the writ petition. In other districts, there is no post of accountant. Writ petition 662.
So other districts, they don't have accountant.
No. Only in 4 districts, my lord, when the district has been formed, my lord, separate judiciary has been my lord established, this post has been my lord introduced. Otherwise, my lord, in other districts, my lord, the accounts person has been maintained by the my lord LDA or my lord LDA.
Hmm?
In my lord, other districts, my lord, so far accounts part is concerned, it has been my lord, looked after by the LDA, either LDA or by UDA. In other districts. In practice, my
So in Assam, we have only in 3 districts accountant,
4 districts.
4
Three
districts.
districts.
Those are all the Boroland districts.
Talguri, Sirang and Baksam.
3. Kokrajhar?
Then it is.
Not in- As per this notification. Initial appointment gives
You
me
know,
the
although it is sanctioned in 2007, my lord. Case 30 of my.
Now you don't have UDA.
Yes. I have-
As of now, there is no UDA.
No, madam.
Huh?
EDA, there is no EDA, post of EDA,
There is no UDA, Lutte.
according to this note.
If we see the finance notification, there is no UDA.
5, serial number 5, serious the within the UDA has been matched. Serial number 5. It's there.
Upper, yes, UDA is there. Upper division assistant. So a upper
Yeah.
division assistant can become,
At this,
what is his name now?
my lord.
Upper division assistant can become this one. Seristadar Munsif. For head assistant,
At this,
head assistant. He can become a head assistant. Now, the pay scale of head assistant, Seristadar and Seristadar Munsif and civil court are one and the same,
An accountant.
isn't it? No, no, no. Head assistant is PB3
yes, madam. At this is senior.
and Seristadar civil court is PB3. Whereas a Seristadar Munsif can also apply to become a head assistant.
Yes.
All these are in the category of UDA.
Yes.
No, their grade pay is different. Na? They would not come within. Only the persons will come is in from bench clerk 3.
PB2,
Where is the bench assistant one? Mr. Mr. Sharma, your case, you were appointed when? As, how do you were you appointed?
I am appointed in 1907 in Mongoldoy, madam. You have to apply PSO number and
No, you were direct appointment to the post of accountant.
from LDA, I am promoted to the accountant.
So you from LDA, you got promoted to LDA accountant.
Accountant, madam, your
Where is that?
page 21 annexure 1 is my petition.
Page?
They select candidate C joint opera son of so and so. Grade Iman in the district of Durham is temporarily appointed as lower division assistant in the post created by Jason so and so. 96 under the.
This assistant,
establishment of
then the
division
promotion
section
there.
number On Iman and Iman, it is my lord, 97 my lord. 97 he was promoted, appointed as the extent. And thereafter he was transferred to Udalguri, my lord. As per his office, transfer by communication that is demand. He is joined over LDA office now, working in the PTS office in Mongoldoy is hereby released from this establishment on 99 afternoon to enable him to join in the assignment established subdivision in judicial magistrate Udalguri. In 96, my lord, 99 he was promoted or transferred to Udalguri. Since
Huh?
then,
He is hereby released. LDA release
to
in
join
the
in
PP
Udalguri.
office, now working in the PP office, hereby released from the office today. Afternoon to enable him new assignment in the office of the subdivisional area.
Udalguri.
Now, what happened thereafter? How did you become the accountant?
By 2010, my lord.
How? Where is your promotion? So and so, the second senior most so
The
and
page
so
20
working
and
as
except
this
for-
assistant is promoted as man in the newly created.
He joined the senior most lower division assistant, working as a bid assistant is promoted to accountant man. He have page 28 and except for. He was promoted to early 2012 man. 2012 he is promoted to accountant man. And since then he is duty. the scales of pay and allowances are administered as per rule. Okay, I mean,
So therefore, it is being done interchangeably, whatever these people feel, isn't it? So therefore, can't we apply now the judgment or the affidavit which have been filed by the state? The High Court has not stated anything. These are the three posts which have been created of accountant in the district judiciary. So when these three posts are now being created, and these appointments are made from as a promotional post from LDA. So therefore, they are not brought into a different cadre. They are in the same cadre. It is only the insertion of accountant in which have been given, and they have been therefore interchangeably. The person who is an accountant is then made a bench assistant also, which is also held by UDA,
Yes, yes.
isn't it?
like Milord, all are in LDA. Is it like whether you want go for the accountant post, he has been sent to accountant, subject to Milord. It's like that procedure followed. No norms, nothing has been there. If someone wants, yes, I would like to work in the account section, all right, you go amongst the LDA Milord. And one wants to work as UDA, he becomes an UDA. That process cannot lead to, that is my submission as an officer of the court. That situation or that procedure should not lead to a conclusion in the higher court. Merely because I went to the account segment or branch from LDA.
More so when
Origin is the same,
more so when your right to promotion was to the UDA.
exactly,
But as there were different posts being created
created,
equivalent to LDA,
correct.
UDA, so they have been appointed to UDA accountant.
So my going or my movement cannot curtail my height of consideration for the next higher post, which is high resistance. That is why I mean,
It seems to be a more logical.
correct.
It's a promotional post. How do you know there's no rules made?
For this concern, no person has been.
So let us not go into that.
Yes.
No,
Yes, sure.
that will be another Pandora's box it will open. So let us not go into that, but we make it. Okay, Mr. Bhattacharya, what do you have to say? Mr. Sharma, please give him.
But the rules does not contemplate the post of accountant. No. The rules have not been amended after creation of this post. And in the advertisement also, there is no mention that the post of accountant can also apply. Therefore,
But how do you take care of Article 14? That a person has a right to be considered for promotion is a fundamental right. How do you take care of that situation? Because they were promoted to the post of accountant. Being an LDA, without giving any importance, there's no different pay scale, nothing different, everything is same. And they are interchanged. Today he is given accountant, tomorrow he is being sent to bench assistant. Third day he is again put as accountant instead of an LDA. All these things are going on everywhere. But the fact remains that he was initially an LDA. And having a new post which has come in, and the authorities have taken it as a promotional post on the basis of the pay. Now you see, therefore, here you therefore touch the government's affidavit. The government affidavit says that they are equivalent on the basis of the pay, which is therefore they
that
come into the
affidavit I
picture.
don't have.
Understood, the rules are not. But if the rules are to be, the rules categorically say it is only the UDA. who can become a head assistant. No quarrel with that proposition. But can't it be taking into account the right to be promoted? Is a right to be considered for promotion is a fundamental right. Can't it be therefore say that his right to be considered for promotion cannot be thwarted on the ground that he is in a post, which is everywhere it is interchangeably used.
But that could have been taken care of by the judicial department by amending the rules or making any notification thereafter, by recognizing that these two posts are equivalent. Had there been any clarification at any point of time, the case would have been there. But they have just created one post and that person was appointed there as a accountant. Nothing more than that. Without there being any recognition of that post regarding the equivalency, they cannot come into the picture.
Now, there is another document by which there is the equivalence of this is given to the LDS, which is the subject matter of challenge in that batch. Copies then all. So there is a equivalence being granted by the government.
Yes, government, first, High Court also issued notification, then government issued notification. First, the High Court in the administrative side had issued the notification making them equivalent in terms of the draft rule. Because in the draft rule, all these four posts were made equivalent. Because although what my understanding is, my lord, rules were of 87, my lord. At that point of time, this accountant post was not there. So there is no question that rule will have something into it with regard to the accountant post. Now, if perhaps subject to what my learned brother says, if the person who was promoted in the year 2010 to the accountant post, had he would have known that I'll not get the next higher post of head assistant by virtue of my coming into this accountant post, perhaps he would have never opted for his promotion. So the thing is in a flux, although rule doesn't provide for inclusion of the post of accountant, perhaps by in exercise of power under Article 226, relying on the pay notification issued by the government, this court, my lord, can declare it to, as well as in the attending facts that the persons are traveling from bench assistant, accountant, UDA in all the three categories of post. In that view of the matter, Lordship can read it down and take a conclusion that yes, in view of all these three circumstances, applying Article 14, right of consideration, you cannot curtail.
Then wouldn't the Nazir also become Nazir supervisory
Lordship-
assistant?
Lordship would not go Nazir supervisory
No,
assistant.
because the
if
more,
they-
because then you see, if I read only them,
My lord.
because this judgment should, then is it required therefore a person who is the Nazir to again come before this court? Because when I am reading down, reading down a rule of 1987, saying that the head assistant UDA shall also mean so and so. Can I say that the Nazir would not? Because he is also a promotional post to LDA.
1 second.
Okay, with 2 o'clock.
What taken consent from the petitioner, I request that
You want to withdraw the case? What's your name?
Miss S. Das.
Huh?
Miss S. Das.
There's a stay.
Stay was already vacated by your lordship.
I vacated it.
Yes, sir.
Ms. Esthas, the learned counsel appearing on behalf of the petitioner, submits that she has instructions to withdraw the instant writ petition,
Civil revision.
the instant application. Mr. S.C. Kayal appears on behalf of the respondent number 3, 4, and 5. Taking into account the same, the instant application stands closed. It has been brought to the attention of this court that the interim order was earlier vacated. Therefore, there is nothing, therefore, the learned trial court shall proceed. Trial court, no?
Yes, sir.
Trial court shall proceed with the disposal of the suit
Good.
in accordance with law. Yes, Mr. Bhattacharya.
I would require 1 day. Another day for argument.
Why?
Arguing this matter. I have found one judgment.
Huh?
I have found one judgment regarding this equivalence.
Is it a case of equivalence or it's a case of non-consideration? Because it is not clear from the actions on the part of the district judiciary as to whether the post is equivalent or not. That they have not. They have promoted him, who is otherwise eligible to be promoted to the UDA, as an accountant. How does it make any, means the problem which arises is it is not his fault. They have promoted him to the post of UDA accountant in place of UDA.
But what I have understood, I just read this judgment.
Because there is no challenge to the appointment of these petitioners or the respondent out here to the post of accountant.
The difficult declaration on the part of the authority that these posts are equivalent. That has to be done.
No, till the rules are not framed,
And otherwise also.
till the rules are not framed or the High Court having not issued a this court can very well say that this, for this purpose of these cases, it should be treated as both that it is a post promoted to the post of UDA. Or the accountant shall be, post of accountant shall be, why should I go into the question of equivalence? I need not go into the question of equivalence. It is a post as if it has been, they have interchangeably used the word account, post. They have made themselves equivalent to it. The authorities have made it some equivalent to that. Why should I don't have the power to decide on the question of equivalence. Unless there is a question asked. That is not the question asked before me. So the only question is whether they have a right to be considered for promotion, having been promoted from LDA to accountant, which is a new post, and the authorities have not decided anything. The state, on the other hand, says it to be equivalent by the affidavit. Isn't that enough for me?
The difficult, I don't have the affidavit first.
But
My case where they have not filed or not that affidavit, I have not gone into. Let me go through this judgment for the,
what judgment is that?
it is 1974 4 SCC page 3.
What was
So
that?
let me go through, my lord. I am on the,
Let us
in the
both
middle
go
of-
through together.
it's a long judgment.
It won't take much time. Let us go through together.
1974 4 SCC page 3. E.P. Royappa versus state of Tamil Nadu and another.
1974.
4 SCC.
Page.
Page 3.
Are you sure? 74?
Yes.
3 SCC.
74 4 SCC.
Earlier, this citation I used to remember
For contested matters.
as AIR 1974 SC 555. EP Royappa, famous for the purpose of deciding the point that when you are alleging malafide, what is the how the court has to decide that. That is one of the most important. Let us see what is there. Transfer inter area whether appointment to a new cadre post, whether requirement of declaration that the post is with in status and responsibility. Paragraph 81.
Now turn to the first round of challenge which alleges contravention of the second proviso so and so. So far as the second proviso so and so it is concerned, we do not think it has any application. Merely refers limited authority on the state government to make temporary addition to the cadre.
Now
Or-
kindly see that fifth line. The strength and composition of the cadre can be determined only by the central government under Rule 4.1. And the central government alone can review it triennially or at any other intermediate time under Rule 4.2. The state government cannot add to the cadre a different category of post than that already existing in the cadre, nor can can it make any permanent addition to the number of posts of a particular category in the cadre. For to do so would mean in the first case alteration in the composition of the cadre, and in the second alteration in the strength of the cadre, both of which would be impermissible to the state government. But the state government can, by virtue of the relaxation granted by the CM, make temporary addition to the cadre post, provided the post added carries duties or responsibilities of a like nature. This would mean as so and so. The exercise of this power by the state government with reference to a post involves. How this judgment will be applicable? Here, kindly see, in view of 235 to 34, it is the governor who can make the rules in consultation with the High Court. Now, the rules have not been made, or there has not been any amendment to the rules. But by way of executive instructions, these posts have been created by the authority, by the governor, and in concurrence with the High Court. So if that be done, wouldn't that be a power exercised under 234?
Then there is the creation of this post. There is no additional line to that effect, that how they are going to treat these posts, in what category.
So therefore, now the government's affidavit comes in the picture, wherein it says that it is equivalent. Now, you see one thing, these posts being created in the year 2017 or 7.
Seven.
These posts having been created then, the question therefore arises is, these petitioner or the respondent in the case, they have been promoted from LDA. Although there is, for these posts, whether they are promotional posts or not, nobody knows. But can't it be presumed, taking into account that the government or everybody had acted on thereupon, by which they have been promoted from the post of LDA to the accountant. And thereupon, these accountant posts have been interchangeably used with the bench assistant. And the bench assistant being post which is manned by UDA. So the question is, they have been appointed not to the name of the post. They have been promoted to the cadre of the UDA.
Then that will be reading too much into the what is not there in the.
Everything is in vacuum. Everything has to be read down because nothing has happened. If there is nothing on record, here the government have only created post. There is no mention that as to whether that post will be the promotional post from LDA. There is no mention whether it will be a direct recruit post or it will be a promotional post. No mention. But on the basis of that, the authorities concerned and in concurrence with the High Court have decided out there and gave them the promotion to the post of the accountant. This is going on. Now, when these promotion to the post of accountant has already been given, this is also in Beckham. There's nothing mentioned anywhere whether the LDA can be promoted, whether the feeder category of the accountant can be of the accountant can be an LDA, nothing is there. But they have used the post in the name of the accountant and used it as an UDA. Otherwise, our accountant is to be only given the post of an accountant and who has basic knowledge of the accountancy. If you see the Guwahati High Court rules, if a person has to be appointed in the post of the accountant or something, he has to have some degree on accounting, which is not there in in respect to this. Neither the government has framed any rules for that. That what is the eligibility criteria to be appointed. So therefore, it is the name of the post which is there, but it is whether they have been used as an accountant or not, nobody knows.
Basically, they are LDA. Basically, they are LDA.
UDA.
Yes, sir. Sorry, Milord. UDA. I'm sorry.
This is what is happening. So everything is in Beckham. So what is wrong, therefore? As there are no rules which shows, so it is they are using it as an UDA. Otherwise, that LDA could not have been promoted to the post of accountant.
You can,
Royal judgment is in the respect of that the state government have been given a power to have for 1 year a post, a temporary post,
Non-cadre.
non-cadre. Because these are the Indian administrative pay rules which can only be made by the state government, central government. Now, if the state government is allowed to amend it, it would be taking away the right of the central government, which only it is reserved for the central government. So therefore, it was said that unless the central government allows it, this cannot be inserted to that effect. This is the basis on which it is ROIPA comes in. Paragraph 81 and 82 makes it clear on that. But the question out here is they have used the post of the accountant only as in the name of the accountant, but
Tag.
it is actually an UDA.
it's a tag only, Milord. It's a tag only.
The tag.
And in
There is
fact,
no qualification also. The state have also not provided what will be the qualification for being an accountant. Nothing has been provided.
in fact, your lordship, subject to correction, my lord, your lordships can have a look at the draft rule. If your lordships has a copy,
I don't have.
my lord, I'll just furnish. The accountant, my lord, will have a look at this page because senior administrative assistant, accountant, my lord, the promotional criteria is same. There has to be residency service as junior administrative assistant, that is LDA. And Nazir is also equivalent as senior administrative assistant.
Now UDA is senior administrative assistant.
Senior administrative assistant.
Same.
Exactly, totally same with that of the accountant.
But accountant can be promotional as well as direct recruit,
Yes,
which is not there for senior.
no, it's not there.
Because you see, if you are sending it to the rule-making committee, the rule-making committee cannot decide on that.
Ultimately, rule-making committee will also follow the draft rule, perhaps. Because in the earlier instance, rule-making committee followed the draft rule.
How can it follow a draft rule which is going to come into effect?
That's true, my lord. But interim arrangement was made by issuing a notification. And I think
That is not permissible.
after the government's response, my lord, vis-a-vis comparison of this draft rule of this.
It is only a post being created
Correct.
with the
In
pay
all-
scale similar to that of the UDA.
In all practical purposes, a limb has been created from the UDA, which is a UDA, in fact.
But this is a case where there is a promotion from LDA to accountant. But accountant post can be filled up by direct recruitment also.
No,
No.
here, in this
Same.
case, there is nothing.
In this case, nothing.
You see, that is for the draft rules. It can be done from direct recruit also. That is another thing. But in this case, there is nothing to the effect. Yes, who is appearing for Mr. Sharma's other side? The private respondent? Is there stay? No. Is there stay, Mr. Sharma?
Stay, essentially.
Stay
Subject to outcome. Subject to the outcome.
Yes, there's no stay.
No stay. He has already joined.
Why he has not appeared? This is regards service upon the respond number 5, yes. Lozima Court, notice of Lozima Court service. We do one thing, but Mr. Das, one thing, there is always a problem. I don't think the rule-making committee can do anything in this respect. They may give anything on affidavit, that's a different thing. The question that it has to be treated as for all purpose it is so and so. It cannot come within the ambit of the rule-making committee. The rule-making committee's decision can at best be as to whether they are equivalent.
Yes, correct.
But the rule-making committee's thing cannot come on the present facts as to whether the petitioners or the respondent out here, having been promoted from LDA to the post of accountant, and there being nothing, no stipulation as to how a post of the accountant is to be filled up, that it is required to be treated as a limb of the UDA, as you say, cannot be said by the rule-making committee.
Rule-making,
That can only happen by judicial decision.
on the given facts of the case. Because facts may differ, my lord. If, tomorrow we may come up, we may face another facts wherein it may not be possible to.
Tomorrow
derive-
there might be a direct recruitment. Now, this direct recruitment has been done. It, although there is no stipulation how it is being done. That will be again another aspect. But here, the question is the right to be considered
Consider.
under Article 14 is the issue. And the Article 14 and 16 is the issue. So therefore, it being a fundamental right, so they have a right to be considered because they were promoted to a post which have been only created as a limb.
Because normally when a post is created, immediately the next duty of the government is to frame the recruitment rule, the very next duty.
Now,
Because
or with the concurrence of the High Court,
Yes,
come up as to how to fill up that post as it's a new cadre post.
central government, my lord, even after a cadre review, if some new posts are included or cadre restructuring, some new post is included, immediately central government issue the notification, publishing the new set of amendments.
Why
or
you
the
are
new-
going into the central government?
I
And if it is for the state government also, they would have done it.
The state government, we don't have cadre review, cadre restructuring, nothing, my lord.
No, state government also it would have been done.
Yes.
It is not being done only because it's the judiciary.
Yes,
Where is the government? Again, some thing has to be said. The government, no government is here. They are not bothered. High Court bench, so no bother. Because they have come up with this thing. So they have gone into the question of
in fact,
equity.
many government has said, in many words,
Now, the government has said
government
that.
has clarified that position.
That aspect has been brought in.
So even whether rule comes or not, we cannot, perhaps,
You do one thing. Where is the respond number 5 working? Under whom?
Udalguri, I think, 1 second, my lord.
Hmm?
Chief Judicial Magistrate,
Of
Udalguri.
your case is Chief Judicial Magistrate, Udalguri. Okay. You do one thing. You give an extra copy of the petition to him so that he can serve it upon the respond number 5.
Private response. No, sir. No. Extra copy
Mr. Nath,
Respondent number 5.
here the question which is happening,
Here one I.
I've seen your affidavit. Your affidavit says that as they may be treated as equivalent, taking into account the pay scales and all. But interestingly, if you see the facts out here, it will be seen that these petitioner and the respondent who have been made the accountant were promoted from LDA. Although there is no stipulation in any rule or any executive instruction that the post of the accountant is to be filled from the post of LDA. There is no stipulation. It is further seen from the materials that this post of accountant is only in the name. It is in fact another limb of UDA. Because this very accountant is tomorrow transferred inside the judiciary and made him the bench assistant, which is being taken into account as a UDA, manned by the UDA. So it is only in the name the post is. Otherwise, in all effect, he is a UDA. So therefore, the question arises, as these people were all LDAs and senior in the LDA cadre, they were senior to the respective other persons. Wouldn't not allowing them to participate, wouldn't it take away their right for consideration for promotion, which is a fundamental right? Because the state government have not framed come up with anything, any notification with the consultation of the High Court or the concurrence of the High Court as to whether these how to fill up the post of accountant.
In absence of that, LD in absence of that, LD as appointed that account.
Promoted. So normally LDA promotes to UDA. But this is used as an extra limb of UDA and they have used it in this manner. It's only the nomenclature of the post. Nothing remains. Okay, we do one thing, we'll have it and finish it off on 17th. You give an extra copy to him. Yeah, we'll finish it off. And by that time, I am sure the rule-making body won't do anything. So I'll take care of that. This judgment. I think this is the best way out. Because the state has not come in. It is just a name in the post. It's only in the name, nothing is there.
In fact, the state authority doesn't want to enter into that because they said that it is for the High Court, the committee of the High Court, they are to look into, they are to examine. Ultimately, what is the function, what is special
If
function?
that be so, then why did the governor did it for this LDA? LDA copies, typists and all together. They could have very well done it. When you are creating a new post, which is in fact not there in all other districts, except those 3 districts. It should have been done. How do you promote? Nothing is there. I think what I have thought about, I'll just put it in the order so that I remember it. Yes. Heard Mr. K. Sharma and Mr. A. Bhattacharjee, the learned counsels appearing on behalf of the writ petitioners in WPC number 7112/2023 and WPC number 662/2025. I've also heard Mr. H.K. Das, the learned learned standing counsel of the Guwahati High Court, and Mr. D. Nath, the learned counsel appearing on behalf of the Judicial Department of the Government of Assam. In both the writ petitions, the issue involved is as to whether the post of the accountant, whether the post of accountant would be a feeder category post to the post of head assistant. More so when the rules framed do not specify so. This court had inquired with the learned counsel and pursuant to orders being passed, the Judicial Department of the Government of Assam had filed an affidavit stating inter alia that the post of UDA would be equivalent to the post of accountant, as both draw the same pay scale, are in the same pay scale with the grade pay. First, this court had also inquired with the learned counsel, standing counsel appearing on behalf of the High Court, Guwahati High Court, as to whether High Court, and in that regard had directed the Guwahati High Court to file an affidavit on 29/5/2025. However, the learned standing counsel submitted that the matter has been placed by the Honorable Chief Justice to the rulemaking committee for a decision in that matter. In that regard, the learned counsel have placed before this court an instruction issued by the Register of Vigilance to the standing counsel dated 25/6/2025, which is kept on record and marked with the letter X. XYZ হৈছে নে কিবা কিবি? মই যেতিয়া মেটাৰবোৰত XYZ কৰো নহয় চাব দেই হা ইয়াত XYZ এইখন আছে X এখন আছে নেকি নহয় এইখনতো আমি দিয়ে as X. From the said communication, therefore, it is clear that there is no decision taken by the Guwahati High Court on the administrative side as to whether the post of the UDA, a post of the accountant, would be the feeder category post to the post of head assistant. First, this court have also perused the materials on record. And from the materials on record, in the case of the petitioner in WPC number 7112/2023, it is seen that the petitioner was initially appointed as a lower division assistant. On the basis of an order dated 16/7/1997. Subsequent thereto, on 31/3/2007, the government of Assam in the judicial department had created various posts created 158 posts for the 3 districts of Udalguri, Sirang, Baksa. And while creating those posts, 3 posts have been created for the post for 3 posts of accountants. Accountant was created. The materials on record also do not show that the state government or even the Guwahati High Court have framed any rule or issued any notification as regards how the post of the accountant is to be filled up. First, the record further reveals that the petitioner in WPC number 7112/2023 was promoted to the post of accountant from the post of LDA. On the basis of an order dated 17/3/2012. First, the record also reveals that the petitioner in WPC number so-and-so 7112 have been also transferred to various posts which are manned by the upper division assistants. First, next. The case of the respondent in WPC number 662/2005, private respondent, is also similar in as much as the private respondent was initially appointed as an LDA by an order dated 7/3/2014, and subsequently he was promoted to the post of accountant by an order dated 24th of January 2020. The record also shows that the private respondent have been transferred within the said district, within the establishment of the district and session judge Udalguri to various posts which are manned by the upper division assistants. The materials on record next therefore suggest that the appellant, that the petitioner in WBC number so and so, that the district administration, the district judiciary in question the district judiciary of Udalguri, now both are Udalguri, the district judiciary of Udalguri have used the post in absence of any rules or notification issued by the government of Assam as well as the state government, as well as the Guwahati High Court. As a limb of the post of UDA. First, in the backdrop of the above, the question therefore arises that the petitioner in WPC number 7112/2023, as well as the respondent, private respondent in WPC number 662/2025, can be denied their right to be considered for promotion which is a fundamental right as well established. First, this aspect of the matter, this court would deal with on the next date, taking into account that any decision made in the present proceedings would have an impact on the appointment of the respondent number 5 in WPC number 7112/2023. As the said respondent remains unrepresented. It is also seen that though this court have, on the basis of the Lozima court order, have deemed that the service upon the respondent number 5 is complete. But in the opinion of this court, as the service upon the respondent number 5 can be affected through the Chief Judicial Magistrate, Udalguri, under whom Udalguri, who is the respondent in WPC number 7112/2023, and under whom the respondent number 5 is discharging his duties. The interest of justice would be met if a fresh endeavor is made to effect service upon the respondent number 5 through the Chief Judicial Magistrate, Udalguri. Mr. K. Sharma, the learned counsel appearing on behalf of the petitioner, shall serve a copy of the writ petition to Mr. H. K. Das, the learned standing counsel, during the course of the day. And Mr. H. K. Das and the learned standing counsel of the Guwahati High Court shall ensure that the copy of the writ petition is served upon the respondent number 5 and a report thereupon is placed before this court by the registry. List accordingly on 24th of July 2025. The respondent number 5 would be at liberty to file any reply if so advised. I've noted it down.
Yes.
I won't forget.
No, it's always better.
Huh?
It's always better to use.
And this order may also help your rule-making committee. Along with item number 1 or 2.
1.5.
Yes, what is your affidavit?
But I have filed it.
Flag D. What does it say? Of the issue involved in the inquiry pertaining to a challenge presented by the petitioner.
Basically, what I have said is that they cannot determine the pool or the feeder cattle.
Huh?
Because, Lord, the determination of the feeder cattle. Here, my lord, they are basically agreeing that they are, what I say, they are sent for more competition. Because the vacancies of grade 1 was made open to all, irrespective of category. Now, their contention is that it's not that their right of consideration has been violated. If I say it otherwise, their case would be that their chances of promotion has been limited because other has come. Now, I have given Milot data wherein in 4 recruitment processes, lot many number of posts remain unfilled because ultimate selection is not based on the feeder cadre or any qualifying marks. It's solely based on merit. Whether you belong to 3 or 2, ultimately you have to score marks out of 50. Then only you will get promotion to grade 1. So in the
In
given,
other words, to make it more simple,
yes, my lord.
a employee will have a right to be considered for promotion,
Correct.
but would have no right to fix the zone of consideration. That's your submission.
Yes. And additionally, chance of promotion is not a condition of service, my lord. Chance of promotion, that your scope of promotion is limited by an action or a decision of the government or the authorities. My lord, it's not a condition of service. And if it's not a condition of service, in the absence of mala fide or any unreasonableness, my lord, that challenge cannot be made. This is
But
another-
wouldn't that be diluting the city commission recommendation?
Here I am coming, my lord. Now, the question is always with me also, why this, there were 17 posts, 32 grade, 2 were there. Then why this inclusion of grade 3? Now, the most important aspect is that even if there is 50 grade 2, they know that itself may not lead to filling up of 17 posts, taking into account the merit. Because whatever be the feeder post, whoever be in the feeder post, the selection or recruitment has to be based on merit. You belong to grade 3 or grade 2.
Everything is understood, but when the city commission only says that the promotion to the post of grade 1
Yes,
can only be from stenographer grade 2.
Yes.
One-time exception is understandable.
yes, ma'am.
Two-time exception is understandable, and
Yes.
third, it becomes a habit.
No, it's not habit. I'll address. The reason is that even out of 35 grade 2, only 5 could achieve the cutoff mark below. So in that means if we only depend on grade 2 pool, then 5 has cleared the cutoff. So out of 17, 12 posts would have remained unfilled.
This time.
Yes. And their contention is that we have,
No, I understand. Your contention is out of 50, 30 marks you have to get.
that is the eligibility. And thereafter, as per merit position. So we cannot compromise the merit.
Thereafter, what merit is done?
Hereafter,
this
they are
is-
saying cutoff marks will be 46 point something. Though they have said 30 is the eligibility, now as per merit, the cutoff marks will be
No,
46.
Selection will be purely
That
based on merit.
beyond I don't know.
Selection will be only based on merit. Whoever score more marks, he will come 1, then 2, then 3, then 4. 30 marks is,
Where is it mentioned in your advertisement?
yes, Vinod, it's mentioned.
Let us see that.
And apart from all these things,
Hmm.
the another aspect is that, my lord, they knew all these things prior to advertisement, prior to publishing of the eligibility list, that grade 2 and grade 3 were included. But there was no protest, no challenge to the same.
Malado, before my friend.
They did not challenge to the same because I didn't pass the judgment, na, earlier. Yes. After I passed the judgment, he became clever.
But no, one thing, process of the merit in the affidavit,
My lord,
your lordship may
I'm
look
sorry.
into that.
Brother, X second.
Mr. Rachari, I know your case. This is the second round of
Here it is something which cannot be at present, cannot be acceptable, my lord.
Let us see the
Only your
advertisement.
lordship may look into para 9, my lord, just for a
Let
moment.
us
My
see
lord-
the advertisement, page 26.
Yes. If your lordship kindly turn to
Page 26.
page 26, my lord will kindly see, Roman 1, for promotion to stenographer grade 1, completion of 5 years service as stenographer grade 2 or grade 3 in the district judiciary of Assam. So this was never put to question after the advertisement. Then down below, my lord will kindly come, speed test shorthand speed of 80 words per minute, duration 7 minutes, so word, 50 marks total.
Hmm.
Then, my lord, page 27, serial number 5, candidates securing 30 or more marks out of 50 will be eligible for promotion to grade 1. So this was mentioned there. in the earlier round of litigation, my lord, they approached this court. Your lordship was pleased to dismiss the writ petition on the ground that they did not challenge the resolution of 2018. Now, this time also they did not challenge the resolution.
Are you doing this again on the basis
Yes.
of 2018?
And my lord, the signature of the judges is after 19, my lord. You just look into paragraph 9, my lord. They are suppressing some fact which is not acceptable.
But I don't.
My lord,
suppress
para 9,
facts.
my lord, your lordship may look into, your lordship may just look into para 9.
I don't.
But let me announce, let me say that para 9, my lord,
haven't been
of the affidavit.
Nine,
Their affidavit.
But I have stated in the affidavit,
Let me
whatever
announce
I
the
have.
para 9.
yes.
My lord, that with regard to the statement made in para 12 writ petition and signed Tribunal states, notification dated 9/12/24 was published in terms of the decision content in the resolution dated 22/2/18 by this committee. And the resolution, my lord, annexed as R2 is 22/2/18. Your lordship has found it?
Hmm.
My lord, and your lordship may turn to page 167.
167.
167.
Hmm.
How could my lord Justice Patrick Shoika and Karthik Akte get signature in 2018 when they were appointed in 19 and 23?
No, no.
This
my
is,
lord.
this is
I'm sorry.
2018, no date is given in the resolution.
No, I'll just explain, my lord.
How is it that they have written that it is 2018 resolution for which the advertisement has been given? And this resolution, I don't know, my lord, where from it has come from. No date, nothing. And
No.
Justice Patrick Shoika was appointed in 2019 and that is Karthik Akte on 2023.
It was a wrong on my part, my lord, because I annexed the 2018 resolution. This was the resolution which was taken before the this advertisement following the earlier one, 2018. 2018 resolution to assess. One second.
Only 2 days back, they have filed all the affidavits. Only
my
2
lord,
days back, they have filed affidavit.
There
One
is-
day before, they have filed. So, my lord, if your lordship gives me some opportunity to file some counter, my lord, to that. Your lordship permits me. my lord. These things which we found in the day, my lord, your private respondent has also filed affidavit. This resolution of page 167 does not contain any date.
From 2016. The 18 resolution from- But I was supposed to annex this one, but inadvertently, my lord, the latest. The
Actually, this is the basis on which we have done.
no, the basis was that,
No, it can't be
Lord-
the basis of 2018.
no, lordship.
If you are saying on the basis of 2018, you are doing it in 2024, then how can you do it in 2024 on the basis of 2018?
Was the last decision that it will be open to any grade and it will be 5 years, that was in 2018. But
What
Yeah.
what does it say in 2018?
it will be open to any grade. The vacancies will be open to any grade. That is there. And it will be 5 years.
What 5 years?
The residency service.
That is okay. I'm not on
Because-
that. But that is, you see, you are doing
One
it.
time.
These are one-time business.
Exactly. So this notification that your lordship has seen in the edition, lord, affidavit in opposition, this is with regard to that one time. Since we cannot mechanically follow the 2018 without any exercise, so that's why it's like an approval taken from the committee to follow 2018. Because the last decision was in 2018, that it will be open to all and residency service will be 5 years. That decision was taken in 2018. I'll file an additional affidavit bringing on record the 2018 notification, resolution, my lord.
Why do we need 2018?
2018, the resolution.
Why do you need it? How is it
If your lordships-
2018
if-
has
if your lordships
relevance?
Recollect, the first decision
No,
was,
understood. 2018, when you are going for a one time, because you are saying every time it has to come up with something to that effect. Because you see, the SETI Commission's recommendation is very clear that For the purpose of promotion to the post of stenographer grade 1, it will be from stenographer grade 2.
Another, there is another 15 years service. 15 years.
15 years is
No,
okay.
15 Important, my lord. Lordship will kindly appreciate one thing. The petitioner's case before your lordships is that we are to follow the SETI commission.
Hmm.
Now, SETI commission recommended that from steno 3 to steno 2, steno 2 to steno 1.
Hmm.
And service is 15 years of service.
Hmm.
If we follow the SETI commission's recommendation in toto,
Hmm.
we get only 2 out of 35 in this exercise.
Where? Where is 15 years?
In SETI commission's recommendation.
Let us see
I
page
have-
47.
No, if your lordships kindly take the 2018 resolution, it's recorded there. The entire resolution is there. The first one, my lord, will kindly have, that is of 2016. For promotion of existing stenographer of subordinate judiciary of Assam, the committee recommends the following criteria as one-time measure for framing the so-and-so. Irrespective of any grade and qualification, they possess existing stenographer who has completed 15 years of service promoted so-and-so. And the
So 15 years will come only in a case that you can take grade 3 also if he has a 15 years. Yes, this is the meaning.
irrespective of any grade, education qualification they possess, existing stenographer who have completed 15 years of service be promoted as grade 1 stenographer, subject to such criteria as regards fitness so-and-so.
So if a person has 15 years, a stenographer who is grade 2 or grade 3 can very well become grade 1 if he has 15 years and passes this exam.
May I just explain?
Please.
This resolution, your lordship is reading of 2013. This was a portion, quoted portion from the 2013 resolution, wherein the committee relying on the SETI commission's, accepting the SETI commission's recommendation, my lord, this 15 years.
So where is the otherwise 15 years? Where is 15 years otherwise? SETI Commission doesn't say 15 years. It is only in this resolution we find 15 years.
No, SETI commission says,
Where?
there, my lord.
Then you
I'll
don't
place-
have, don't come up with all these things.
I'll place it.
Don't,
I'll place
and
it.
every time, how can there be every time a one-time year assessment?
No, one
That means
time-
you are having to just throw out those stenographer grade 2 who are incompetent. They have worked in so many years out there, voluntary retirement 50 years, compulsory retirement 50 years. Give them everything and throw these out. Have better persons in grade 2 or remove grade 2 at all. But you cannot do this. Where every time can there be a city that, okay, this time we are going for a one-time measure. One-time measure. What is this one-time measure? One-time measure, then we have many times measure. Till we don't have anybody, we continue to violate SETI Commission's recommendation, violate or flout the orders passed by the Supreme Court. We are a high court on the administrative side. We can do anything.
It's not that case.
Seems like
It's only because of the conscious decision taken by the registry or the High Court in the administrative side that this 32 or 35 grade 3, grade 2, my lord, stenographer are not sufficient if their inter se merit is considered upon a merit assessment in the speed test for filling of the 17 posts. And that understanding has came on light.
but where is
After
it mentioned out there in the advertisement that the highest person will get it? It will be done on the basis of 50 marks. Whoever obtains highest will get it.
The merit is the only criteria. It will be by the suitability test and merit assessment. The moment merit assessment is done through a suitability test, the ultimate conclusion is that it is purely based on merit. Because seniority cum merit has no role here, my lord. So if it's done on merit, then it will come on inter se merit, the most meritorious person, he will be number one recommended, second one, number two recommended, my lord. That is the method that has been followed. Seniority cum merit has no role to play. The argument of the petitioner that 30 is the eligible mark, that would have been a case wherein the criteria would have been seniority cum merit. If
No,
merit is
seniority of the merit doesn't come. There's
if
no
the-
quarrel.
if the
No,
resolution
there
says
there is
that,
no quarrel with that proposition because SETI does not say so.
Exactly, my lord. If the resolution says that it has to be by virtue of a speed test, the whole idea of holding a speed test will be, my lord, flouted. If we give promotion by 30 marks as a criterion, the whole idea will go vanish. It's a purely based on merit, my lord. So my humble submission is that is why the conscious decision came from the registry of the Honorable High Court in the administrative side, that even if we have 50, not to talk about 35 or 30, 32, even if we have 50, then also we have to include the grade 3 to fill up, because whole idea is to fill up the 17 posts. If we don't fill up or
So the registry knows it beforehand that these 50
No,
cannot
my
fill
lord,
up.
it's all. it's a-
Something
it-
like that.
it's- No,
They
it's a-
know it before the
No,
exam.
Lordship will kindly have my affidavit once for a moment, my lord. Lordship, I have given the data, my lord. Lordship will see in the previous exercise what had happened. Our experience, we have learned from our experience. 2018, page 156, my lord will see. And 2018, 33 posts unfilled out of 38 vacant. 2019, 31 posts unfilled out of 34 vacant posts. 2020, 31 out of 34.
So these are only for grade 2.
So even if
No, I'm asking you, these are when you have taken the grade 2 only. Let us see the paragraph, how you have read it. Paragraph number 3.
Yes, ma'am.
Last portion, the respondents while publishing the advertisement took decision to follow the decision in the minutes of Iman opening the vacancies to any grade because of the lack of sufficient grade 2 employee as promotion was based on merit determined by speed test.
Yes.
The insufficiency of the candidates from Iman is established from the fact that out of 32 Iman, only 5 could achieve the cutoff mark of 46.78. Where is the cutoff mark of 46.78 come?
Last 17th number candidate, he scored 46.78. He scored 46 points and
It is stated that since 2018, the centralized Iman conducted 5 recruitment in by Iman. Even after inclusion of both grades for taking part in the promotional process in grade 1, stenographer grade 1, substantial number of posts remain unfilled on account of failure to acquire the minimum cutoff marks in the speed test. How is the minimum cutoff means 30?
skip this minimum.
No, let us think that the
Lordship-
minimum is 30.
Lordship will skip this minimum. Minimum. Lordship will skip this minimum. It's a cutoff mark.
How can it? No, I don't know. I fail to understand, Mr. Das.
I'm sorry.
How is it possible? On one hand, you have not been able to fill up the post. It is not even the minimum, which is 30. But you have not been able to fill up the post. Then why the cutoff has not come down below 46 to let us see 31? Why it has not come down? Because you have not been able to fill up the post.
Lordship is
Or
saying-
have you put a benchmark of 46.78? No, very difficult to understand
Lordship
this.
is saying why you haven't reduced the 30
No,
marks
no, no.
minimum.
My simple thing is like this. You have categorically mentioned that you have not been able to fill up. Every time
Earlier.
there has been examination and 2018 33 posts unfilled out of 38 vacancy.
Yes.
29 31 posts unfilled out of 34. So these are posts which are unfilled. Now, are you saying that these persons could not get the 30? Or are you saying, because if it is 30, understandable. Both part 2 and part 3 means grade 2 and grade 3 did not get, because they were also participating as per this statement. So both could not get 30, understandable. But if you are saying more than that, obviously the cutoff will come down.
I understand me.
And if the cutoff comes down to 31 also it can come.
But I am,
Or are you having a, what do you call that? There,
No.
some Dr. Associates case will come in 1997 3 SSC page 51.
No.
Hidden agenda.
no hidden agenda.
Yeah.
My lord, this 30 marks is, Lordship will kindly forget about for a moment that there is no eligibility of 30 marks. For a moment. We are a recruiting agency. We want that the most meritorious person gets the promotion. It has to be purely on merit. Now, while we hold the selection, our previous experience was that despite there being a selection process by inclusion of both, by virtue of this not fulfilling 30 marks and other aspects,
Are you saying that they don't have 30 marks in the last selections?
I'll have to collect that data. No, no. No, I'm not telling about this, my lord, exercise. Previous exercise, I'll collect that, my lord.
Or is the Registrar General filing an affidavit without that instruction, or is it
No.
making a false statement?
No, no. I have given the chart also that has been provided to me.
Let us see where the chart.
Yes, my lord. Page 166.
Total applicants having 5 years of experience, 22. Number of stenographers, 14. Here, 8. Total selected 5. Number of stenographer grade 2 selected 5. 33. So therefore 33 is vacant.
In my understanding, this 2018 had happened because of this 30.
Because there were only 22 candidates out of 38.
That's true.
Hmm.
This is for the first time, my lord.
So how much was the cutoff? Cutoff here was how much?
In which year, my lord?
In 2018, page 166.
No, that information is not there in the chart. I can produce that information that how much was the cutoff.
Because you cannot have a cutoff more than lesser than 30. But you can definitely have a cutoff at 31.
Yes.
So you mean to say that
In
out of
2000
22, only 5 got 30. Others did not.
But the things gradually improve, my lord.
Hmm?
The things gradually improve. If your lordships kindly see the facts, this time only we get more grade 2. But that also, we found it insufficient. Because the new draft rule says it has to be 1:3. The draft rule, it has got a detailed procedure for recruitment to the stenographer grade 1, grade 2. It provides that the calling of this zone has to be formed by following 1:3 ratio. So even if
Draft rules.
draft rule,
We are not on that. We are concerned.
so it's an example that what is the ratio normally is. So this time only we found more, but the thing is that if we compare vis-a-vis merit, if your lordships kindly see the merit list, only 5 of the group, grade 2 persons, they could come within that 17%. So merit we cannot overlook, my lord. And their contention is that they received consideration. It's not like that their right of consideration is violated. Their only case is that their chances will have been limited. Had there been
Chances have been limited this time,
this time,
but last time the chance was there.
chance was there. They did not challenge the resolution, your lordships.
No, not on the resolution.
I understand. Last time it was there.
Last time there were 9 posts which remained
Exactly.
vacant.
Exactly. So-
Only 42 were, 43 were appointed.
Exactly. So what now, if we give much credence to their chances of promotion, then we'll have to compromise on merit, subject to what your lordships ultimately.
That I
say.
understand.
So we don't want to compromise on merit. And
Then how do you dilute the SETI commission, sir?
if I take your lordships to the, there are not many judgments after the SETI commission. I have gone through the SETI commission's report, my lord, as well as the 2002 Supreme Court judgment. In the 2002 Supreme Court judgment, Honorable Apex Court, my lord, mentions specific recommendations which need modification, and there is one line that all other are accepted. 2002 judgment. Now, thereafter, the judgment has come recent. There is a judgment of 2024 of the Supreme Court. Supreme Court has said that the SETI commission recommendation is recommendation only subject to the rules of the decision of the High Court. So High Court decision will be there. And second aspect is that, my lord,
Which is their judgment?
this is, my lord, I'll just, 2024 7 SCC 262. It has in detail discussed the implication of the recommendation of the SETI commission
2024,
7 SCC 262.
tell me, you have a copy? Oh, he also has one. Yes, tell me.
There are other paragraphs below. It starts from 26.
The justice area was considered to bring about uniformity in service of judicial officers. The recommendations made by ER in the nature of guidelines, and those will have to be seen in the context of the rules governing. By virtue of the decision in Iman, it cannot be said that the adequate elbow room was not available to prescribe qualifying marks in the interview segment. Okay, so this gives you some space for me to maneuver my limbs.
My lord. And there was no, our whole intention was that.
No, Mr. Das, I am agreeable with what is been done.
Well.
Taking into account if the stenographers are not good, they should not be promoted, they should be thrown out.
Exactly. And it will.
Because it is a headache. If you don't have a good stenographer, it's a headache. So therefore, they should be thrown out, in my opinion. And in fact, they should not be even put out there in this. They should be given like in what do you call the private employment type of thing. May get good salary, everything, bonus, everything, but they should be made in such a manner that they should be good.
Yes.
It should be pure merit. I agree with you.
And our
But the
statement-
question is, the SETI commission's this judgment therefore says to that
Yes.
effect that the percentage of marks which is available can very well be done, taken care of, taking into account that High Court has the power to do that. So therefore, what you have done is okay. But the question is, Mr. Roy Chaudhary, did your clients participate last year?
They participated, but one was allowed to go and didn't got 30 marks. So they failed that exam, below 30.
So these are the two here.
These two are here. They have, one has got 44 point
No,
something.
now 44, but earlier
Below
you did
30.
not. When the candidates were less, you didn't get. And what, let me come back and hear his case. His case is
No, his case is,
or.
or is already clarified by the resolution of 2018. If your lordships read the resolution, it's very clear. All grades. 5 years service in any grade.
Existing grade
means-
3 stenographers who have completed 5 years or will be promoted to grade 2 stenographers subject to such. Which one? Resolution
So-
where? Yeah, for
yes.
taking part in the promotion process from grade 1, be further relaxed to 5 years in experience as stenographer in any grade as one-time measure.
Irrespective of any grade and educational qualification they possess,
Where?
existing stenographer, resolution number 2, my lord. Existing stenographer who have completed, oh, I'm sorry.
Resolution considered EMI month and submitted the.
The last
2000
one.
Yes.
It starts with the word irrespective of any grade. The moment it starts with the word irrespective of any grade, the distinction they sought to be made that the grade 3 service will not be counted. This is wrong. This absolutely misplaced, my lord.
Which one?
When the resolution starts with the word that irrespective of any grade, we need 5 years of service as stenographer. That is our decision
Where?
in the resolution.
Where is it? I'm yet to find out.
I'm sorry, my lord. I'll just play. Lordship will come back, I'll place it.
Because 24/7 is the page 262. They have relied upon paragraph 62.
9 or 62.
Two also, my lord. Your lordship may look into paragraph 63. Paragraph 63, 64 or not. 63. My lord, here the rules provided in the advertisement, it is cutoff marks was 30. Now what they have done, this merit of 46 is, my lord, they are changing the rule after the game has been over. My lord, your lordship may look into paragraph 63. Paragraph 63, there are, let me. So those were where the rules prevail. And the rules, and the person knowing the rules, the minimum marks was that they appeared, so they cannot now say about the cutoff marks. Here, the cutoff marks, they are meeting that it is eligible is 30. But we are saying that 30 is the cutoff marks. Then the 30 commission has to be taken into consideration. Now they cannot say that after the examination that only on the basis of the merit. And the last, in their affidavit, last, Malad, what they have annexed, that they have taken this 18 and they have taken into consideration what they have stated, my lord. Nowhere they have stated that selection process they have given ultimately 5 candidates seeking 30 or more marks out of 50 will be eligible for promotion grade 1. In view of the above, the registry proposes the following. The proposed speed test criteria in table B and the notification seeking application, eligible stenographer for district may be approved. And nowhere it has stated that only the persons who are getting more in the merit wise in the selection will be appointed. Nowhere in this notification it has stated, and this here in this particular judgment, what 24/7 is 62, subsequently para 63 and 64, they have stated that there was a rule. And the persons who appeared, they knew the rule that the cutoff marks is that. Here we will say that the
Let
selection.
us read 63.
Malad. The factual backdrop of the aforementioned case was that there was no prescription of minimum cutoff marks for the voice of the really higher judicial service examination. Therefore, the issue before the court was whether the introduction of the requirement of minimum cutoff marks for interview after the selection process was completed would amount to changing the rule of the game after the game was played. It is note of OT that the court in para 15 of such and such, then the 15 was quoted, that there is no manner of doubt that the authority making rules regulating the selection can prescribe the rules, the minimum marks, both in written examination and vivacity. But if minimum marks were not prescribed for vivacity before the commencement of selection process, the authority concerned cannot either during the selection process or after the selection process add an additional requirement qualification that the candidate should also secure minimum marks in the interview. Therefore, this court is of the opinion the prescription of minimum marks by the respondent at vivacity was illegal. That was said, madam.
64.
64. The above finding in Hemant Malhotra were in the absence of the rule prescribing minimum marks for interview. The fact here are significantly different since the qualifying marks for the interview segment are notified before the commencement of the recruitment process. In line with the settled principle of law, as discussed above, in case of inconsistency in the existing rule with the recommendation, the rule will prevail. So, my lord, there was a rule, but here there is no rule. There was only the recommendation. Similarly, in other cited cases, Ramesh Kumar, the court noted that in the absence of any contrary provisions in relevant rules, the competent authority can fix minimum qualifying marks both in the written and vivacity. It was held that if specific rules provide the minimum marks for vivacity, strict adherence to the same is mandatory. Significantly, the judgment also illustrates the importance of vivacity test in bringing out the candidate overall intellectual and personal qualities. Importantly, in such and such, the fundamental issue was whether the rule of the game could be changed midway through the selection process. However, in the present matter, the petitioners were aware of the rules of the game that the prescription of minimum marks well before the selection process commenced. The distinguishing feature cannot be overlooked. So here we knew about 30, not about 46.78.
30 for what?
Eligible. For that, in 50, if you are 30, then the moment we are eligible, 30 commission will come into. The moment we are 30, in the 30 is the cutoff marks that we have to pass through the 30. The moment 30 is there, then the 30 commission will come into play. Nowhere, even in this particular annexure that they have annexed here, nowhere they have said that it will be only on the merit in the selection that it will be taken into consideration.
So your submission is like this, that once you get 30, maybe grade 2 or grade 3, first preference has to be given to grade
2. Then you come for grade 3. After if the seats are more than the number of persons who have qualified more than 30, then take for grade 3. Otherwise, you would now keep on taking grade 3 every time, but then we are out from nowhere. Now we have to get 49 next time, a person may get 50 also. So we'll never get promotion in our lifetime. So what is the necessity of giving 30, the pass mark? So we'll never be promoted.
So that means it is to be seniority come merit come seniority.
Malad, first of all, Malad, if our
It is seniority come merit.
seniority comes seniority means then merit will be considered.
But did seniority, did SETI commission mention it to be seniority come merit?
No, Malad, only it mentioned that grade 1 is from grade 2. Nowhere it has said that it is from grade 3. But it is from 2003 till today. Every time it is a one-time measure. And their consideration is that the person's last few years they have not been able to fulfill the grade one because they were not qualified. Those who were not qualified, they were below 30. But here we are above 30, we are qualified.
But if there are more than there who are qualified, then
But that is
And
only for a particular, only,
wouldn't that be, if I say that SETI commission will be applicable, then wouldn't it be for this court then to say, then the principle of seniority come merit will come into the play.
Malad, neither SETI commission
Within
said
this
about
code,
merit cum seniority. Neither
then-
SETI commission said about merit cum seniority.
Then
Malad, it was that they have to follow, because Malad, they cannot now say because, only because in the examination, on a particular day, somebody, then only we have been working as a grade three, we have been promoted to grade two. So Malad, the persons who are below us, they will just jump over to grade one. Malad, that then the SETI commission will be go by, no requirement for that. Only that for a particular examination, anybody can come and give it for examination. What is there for promotion? All may be a direct recruitment. This will be a case of a direct recruitment, not a case of a promotion.
so
Because this,
in other words, SETI commission has become unworkable as per them.
as for them, there's nothing, no requirement. Only the direct recruitment, those who will come for examination, if a young stenographer comes and gets 49, you will be appointed. Because merit, his past service, nothing will be considered, never. And the person who was grade three, we are grade three, we have been promoted to grade two. We have been working for grade two from 2014, 13, 14, 15, more than 10 years in grade two only. We have been working previously in grade three. Now also we will not be promoted after getting the qualifying mark also. And what they have annexed is not a 2018, it's a 2000, maybe, I don't know, maybe which year. This 18 we have not been supplied of.
No, this will be 2023. Because
Because what one line says,
you see Justice Kadak Etede. So
And
it has to be before.
after my lord, here registry has obtained the listed vacancies of stenographer grade one as on 9/10/24. So this will be after 9/10/24.
And when was the advertisement issue?
Advertisement, 9/12, 9/12/24.
So it will be after 9/10, but before 9/12.
9/12. 9, it is 9/12/24.
Now tell me what happens if you see, the SETI commission categorically says from grade two, it will be grade one.
Grade one.
Now, if a test is being held every year and there is no promotion, taking into account certain minimum qualifying marks, they may obviously, the test they have a right to hold.
Right.
And it is not being filled up by grade two. Then what is the result if we strictly follow SETI commission?
Then, my lord, if we strictly follow the SETI commission, the recommendation that is at page, my lord, 27, it will come.
No, I've understood, I've seen SETI commissions.
My lord.
Now, if we are to follow SETI commission,
Then it will be promotion wise, otherwise it will be direct recruitment. If we go by the SETI commission, it will be direct recruitment for grade one. There will be nothing of promotion. Because grade three, if grade three are allowed, then the new recruitment.
is grade one the direct recruitment permissible?
No, my lord.
So therefore, I'm saying, how do you fill up grade one then? If they don't qualify the minimum marks?
Well, because they were a notification allowing both the candidates grade two and grade three to participate to a process of selection. They have given, there is no rule, they have given a cutoff marks of 30. The moment 30, if in the grade two, the number of vacancies are 17, notified vacancies 17, and 17 qualifies for grade one. Then they will pick up from grade two, then the grade three will come. If there is some less amount of candidate who are below 30, then it will come to grade 3. Now suddenly after that examination, they say, no, you just take for in a very particular day, somebody has.
No. I'm understood that. I'm not on that. My question is, if you don't find anybody who is getting grade 30 marks of grade 2,
Grade 2.
then what happens? It will remain
if,
vacant.
then there is some.
Till it is not done.
The person, if nobody is from grade 2, then the grade 3 will come. Because they can.
How will the grade 3 come if we follow city commission?
Malak, here they have taken a one-time measure. That,
No, understood. Let us take a whole time measure.
Malak,
If we follow grade 2, if there are no grade 2 who can qualify,
Malak,
even get the 30 marks,
Malak. They go for a fresh selection.
then for fresh selection,
Fresh selection. Go for a fresh selection.
again for grade 2,
Grade 2. Grade 2. If they can continue as a
unless
one-time
you promote the grade 3 to grade 2.
grade 2. And Malak, and if they can continue from 2003 to 2025 as a one-time measure for 21 years, they can go for a fresh selection again if nobody from grade 2 is selected or got the 30 qualifying marks. They can go for, or if the grade 3 who have, go for a fresh selection, then go, if grade 3 are promoted to grade 2, they will come. Otherwise, my lord, every time on a very particular day, your lordship will consider another aspect. Grade 2 candidates are in aged to the person of grade 3. Grade 3 are direct recruitment. They will, in certain conditions, they are much more in the experience, they are less, but they are agile to the grade 2 candidates. So in a very particular day, maybe we fast in written examination, written typing.
No, Mr. Roy Chaudhary, you may say that I am biased, but I would not agree to that submission, to that effect, because I don't want the stenographer grade 1 to be, if he is not there, he should be removed.
Malak.
That is my opinion.
Malak.
I make it very clear,
Malak.
because you should see the harassment it causes if the stenographer
Malak,
grade
grade
1,
can be thrown
the
away.
stenographer grade 1 is your main stenographer who doesn't do properly.
Malak, deadwood can be thrown away by giving some.
This is not a case of they do. This is a case of absolutely. It's a case of they do. And your candidates, your petitioner seems to be candidates of they do. They have not been able to get these simple marks 30 earlier.
Earlier, but this time, my lord,
This time he has got it, but earlier they have not been able to get it.
my lord, person may improve also, my lord. They have improved.
So they have therefore you agree they improve
They improved. They improved.
with the age.
At the age, they have improved with the age.
Then what is the problem with competing with the younger ones?
My lord. My lord, they have competed, and but my only submission before your lordship is this 30 eligibility marks, then there will be no meaning of it. Then we will be considered. Then why not you consider me? Because only after fulfilling the notified vacancy from the grade 2 come to grade 3.
I read another notification somewhere. There were two advertisements, where a person can get some marks and go to grade 2, be eligible, and some marks very promotion to grade eligible for grade 1. Where is that? It was in the earlier case. In the earlier case, they show the notification, some advertisement or something. I forgot. Let us see the 2003. I forgot. Where is that? But Mr. Das, you have referred to the 2018, but at page 169, if you see that resolution which preceded the present selection proceedings of 9/12/2024, page 169, you see eligibility criteria as on the date, completion of 5 years of service as grade 2 stenographer or grade 3 in the district judiciary of Assam. 169. You see, the 2018 resolution which was there, 18 resolution says 10 years of service initially, and then you get only 3 persons. And therefore, you say that you relax 5 years. You relax 5 years. So in any service, 5 years. You see the words used. So this was therefore there in 2018, which preceded that notification, advertisement, that promotion. After 2018, there must have been some other exercise of selection. Whatever may be, as a one-time measure so as to tide off the current situation. Okay. But this time, the resolution which preceded uses the word or. No, you cannot refer to these because it has been said there is only one-time measure. So therefore, these, understood, but here you put it in block letters out there. Completion of 5 years as stenographer grade 2 or grade 3 in the year. You have made it very clear to this effect. 3 or 3. 5 years, where is in any? Understood, but this is not there, which is there in 2018. This is not here. Are you therefore saying that there is no decision of 5 judges or 6 judges sitting out there? There is no decision. 1, 2, 3, 4, 5, 6, 7 judges. You are saying that there is no decision. My goodness. It was not. If it was so, they would have put similar like this, but they have made it very clear. Or, which is Mr. Sheikh's case, should be read as end. How do I do it? Tell me. No, no, because I can't take into account this 2018 for this because you have a resolution. If you had said that the advertisement was made in terms with the 2018, it is okay. But that is not so. You come up with a fresh resolution where it is said or. And then also, in spite of that being put, they have used the word or. Yes. So these 7 judges who said, he didn't know the difference between this and that. Do you agree or not that this, what is content in the bold portion at page 168 is different from 169? Meaning is that earlier it was very clear that 10 years was the thing, any service, but now we have made it 5 years. But here what you have done is for promotion demand, completion of 5 years as stenographer, grade 2 or grade 3 in the district or judiciary officer. Tell me another thing, what Mr. Roy Chaudhary has submitted. Say, look here, once you have the eligibility, I have the eligibility of 30. How do you take care of that city commission then? No, his submission is to the effect. Then look here, you say, no, it's not direct. He say that, look here, you say that you are not finding good persons. And therefore you have fixed a threshold. Okay. And therefore you are bringing the grade 2, grade 3, everybody, although that is against city commission. But once I have passed the threshold, then eligible layer who furnish the options will have to appear in the speed test as indicated, voice testing, dictation 2 minutes, 15, 10 minutes. Where? No, why are you referring to again earlier things? We are not concerned. Come to this resolution. I am not going to rely on this 2018 thing. 2018 has no business. Where is it mentioned here? No, you cannot rely upon this type. Following process has been approved for promotion to grade 1. In view of the registrar proposes the following. The proposed pit test as table B1 seeking application in 1. Subject to the approval of proposal 1, the registry may perhaps initiate event to call for options to issue notice and officer. Any officer may perhaps be nominated for evaluating the transcript to take all the necessary steps to complete the promotion process at the earliest. Where is that? What you are saying? That is not relevant, na? That be so, then why you are holding that eligibility then? Qualification. Okay, what about the third writ petition? Yes, Mr. Mohan. Where is Mr. L. Mohan? Hey, third writ petition kon dekhun notun ta. What is his case?
Of senior service that has to be considered by the
Huh?
party, length of service that has been rendered. So far the minus of 15 years of experience that has been considered by the minus of 2013. And even this case, lordship 5 years has been considered as a cut-off mark for appearing in the test. And the below person who are working below than me, they are selected by the entrance selection process, whereas the advertisement still speaks about the qualifying mark of 30 years. We are getting more about the 30 marks as per the marks given by the.
Where do you bring the seniority concept, Mr.?
Lordship, length of service is the concern because we are holding the field since 2012.
So,
Now, there is no in advertisement, even in the city commission report also, there is no any criteria has been prescribed that this selection process has to be considered on the merit report. That is not the criteria.
so now how do this court exercise the power under judicial review? You want to bring in seniority concept?
Because advertisement does not speak anything that on the merit basis the selection will be held.
It only says about how the selection will be held. Then
Only those person who will obtain the qualifying mark of 30, they will be selected. But even after that,
but there are only 17 posts.
Lordship,
And how do you take care of it? A person who has got 45, 46, 48.
even though there is not a cutoff mark that has been observed in the.
So how do they accommodate? If you are some grade 2.
I'm from a grade 3. Yeah. And most of the person who are selected, they are grade 3 person.
But what are you doing for
your
the promotion
profession
from
gets-
grade two to grade three to grade two?
No such promotion.
Huh?
No
Because
such-
I remember, Mr. Rajchandra, if you remember earlier, in the earlier round, they showed some document whereby there is a promotional criteria being set out in some resolution from grade three to grade two. Where? So a person who is in grade three for 15 years, he can very well participate. Although that is not as per Sethi Commission. Not as per Sethi Commission. No, no, a person who is in grade two or grade three to the post of grade one can participate if he has 15 years of service. So for them, but that is not as per City Commission. That is again independent, one time. So therefore, what is the parameters for grade three to grade two?
Case 53. Direct recruitment 50%. Case 53 of the.
No, no, not from to direct recruitment to grade two.
Sure not.
Grade two is promotional again.
Grade two, 50% from
50%
grade three
grade three
and
to get
50% that.
50%. Okay. So you are filling up grade two? Or you are only allowing this Mr. P.K. Roy Chaudhary's client only remain there? Huh? And how are you filling up grade two? Because you see, where is the promotions being made in respect to grade three to grade two? Are you doing it?
One time measure from 2003 to 25. No grade three, grade two.
There is no promotion from grade three to grade
Grade
two,
two.
or do you have only grade one?
Grade one, grade one. Grade three to grade one.
Or here also we say that the grade two is another limb of grade three is another limb of grade one, grade two, like the earlier matter. Going on. He is a High Court counsel. Okay. He knows everything about all this. High Court, this is direct.
Yeah, not only direct loss, it's a common.
Hmm. Hello? No. Huh? Mr. Roy Chaudhary, why do you want to file reply?
Well, to certain extent about that notification. Now,
That is okay, we'll take care of it. Anything else?
anything else, my lord, private respondent, I have not gone through the.
That I'm not going to look into. That is not the issue. What they write is different. And that is not the issue. The only issue is how do you tackle SETI commission? His main submission is this, all overall everything is. That look here, in this advertisement, you have put out there that the marks on which you are going to take care of the candidates is 50 marks. And when it is 50 marks, so his first submission will be, this goes against the SETI commission. Because it is only from grade 2 to grade 1, you can do it. Second submission would be that even assuming for argument's sake, you can take, if there is a necessity, you can take people from outside the grade 2, but take also the consideration of grade 3. Then when you have put it in the advertisement that 30%, 30 marks out of 50 is the eligible, then you have to follow SETI commission to give first importance to grade 2.
Another submission, they have one time measure, they have relaxed 15 years to 5 years. That one, nothing else, man. Only from 15 years to 5 years. They have not said that we will not take into consideration the SETI. They have taken into SETI commission and they have relaxed only from 15 to that 5 years. That much they have taken as a one-time measure. Balance is their own, not without the rules. They have said 30 eligible, then if it is there, relaxation is 15 to 5 years, then take it from SETI commission. My submission will be that way. Because, my lord, they have said SETI commission was 15 years overall service. Here they have said they have relaxed 15 to 5 years. When it has come to 5 years, only that portion is relaxed. Balance, my lord, they are taking it off their own. Now, if it is 30 marks, then.
No. That is another aspect. They say that it was 10 years. You see, they maintain that anybody who is in 15 years, they can take it. But SETI commission doesn't say that.
Hello.
So that is nothing to do with SETI commission. But the question, what relaxation they have done out here, they continue to hold that anybody from 5 years will be permitted from the stenographer grade 2 and grade 3. So your main issue is, the first submission is, they cannot take anybody from grade 2 and grade 3. They have to take only from grade 2. This is your first submission. The second submission is with a demand saying that, look here, even assuming for argument's sake, they can take the grade 3, taking into account the non-filling of the vacancies earlier and having a minimum qualifying marks for that. But once I get the minimum qualifying marks, see, then also you have to follow SETI commission. You cannot divert then and take the excuse that these people concerned are not qualified at all, not eligible. So therefore, when you meet the threshold of the 30 marks, then you have to take into consideration me and give me as, because I'm a grade 2. That is your second submission.
Subject to my correction.
Yes.
The merit consideration will only come as regards the grade 3. If the grade 2 cannot fulfill the criteria of 30 marks and they are in 7 posts after grade 2 have been fulfilled, then 10 posts remain vacant. These 10 posts on merit wise will be considered from grade 3. This grade 3 will be considered on the merit wise, not from the grade 2. Grade 2 will also only be considered on the basis of SETI commission. They cross 30, they will be taken into consideration the highest marks above 30 in between 50. So from merit wise, they will be selected. And thereafter, my lord, the merit position.
No. Therefore, you see, unless you may want to make it complicated, you say therefore that 30 marks once a grade 2 gets it, you have found out that he is eligible. Therefore, these persons concerned and having met the SETI commission or accepted the SETI commission, you cannot now say that this person even does not meet the threshold not to be appointed or given the appointment. All the grade 2 who have got 30 marks and above has to be first given. Anything remains thereafter is required to be then dealt with on merit as regards the grade 3. You have nothing to say. So your basic therefore submission is once the threshold of 30 is being passed out, then the grade 2 first has to be given preference. And if there is anything remains, then the grade 3 comes in. That seems
That
to
is
be
it.
more logical. Mr. Six's case is when or is being used,
My case is very limited.
Very
Your
limited.
lordship already said, if city commission is taken into consideration, then those who are in grade 2 will be taken first.
I
This
never
is-
say, his
yes,
submission is.
His submission. So, my lord, that will be given and thereafter 3 will come. My lord, my limited submission before your lordship is this. I'll go to page 41.
Hmm.
In 41, my lord, that advertisement. Your lordship will see eligibility criteria. My writ petition, page 41.
Yes.
Your lordship already referred to ORNN. Eligibility criteria and the last date of submission of the applications.
Hmm.
5 years.
Hmm.
Completion 5 years of service as stenographer, grade 2 or 3.
Hmm.
Grade 2 or 3. In either category, 5 years experience is compulsory to be eligible. So, my lord, my humble submission before your lordship, I have implemented 3 persons who were selected in pursuance of respondent number 3, 4, 5, and 6.
Hmm.
So, my lord, they have not completed these eligibility criteria. I am not against others, my lord. I am against only respondent 3, 4, 5, and 6.
Why do you say so?
Because, my lord, they are the person as grade 3, my lord, they have completed only 4 years, 3 months. Respondent number 3.
Respond number?
Respondent number 3, my lord, your lordship will turn to page 36. Respondent number, I'll go to page 36, my lord.
Page 33.
The respondent number 3, my lord, he was appointed on 11/1/19 as grade 3 person. So, my lord, he completed 4 years, 3 months.
He on 15/11/19.
11/1.
No, page 31.
Not page 31, my lord. Respondent number 3 was appointed on
Mr. Say, kindly
Yes,
come to page 31.
page 36.
31.
31, yes. 31.
31.
15,
Now,
11, 19.
First is the number 1 is Bhaskar Brahmo.
It's-
He was appointed on 15/11/2019. Okay.
So he completed, my lord, he completed only 4 years, 1 month, 5 days. And this respondent number 5, my lord,
Hmm.
your lordship. Respondent number 5, your lordship will get at page 32.
Respond
Serial
number
number
6
40.
is at page 51.
Yes,
Serial page 33.
33. Respondent number 5 is at page 32. Respondent number 6 at page 51.
5 is 32. Somen Paul.
Yes, ma'am.
5 is Somen Paul.
Then, my lord, respondent number
Bhaskar
6,
Brahmo,
Pallab Kumar Nath.
Pallab Kumar Nath, and
Nath.
another one, Nath. How many people? 3, na?
My lord, no, here, my lord.
Another one is there, na?
Another
This
one, my lord, page 36. Your
Rashmi
lordship will
Ranjan
go to
Bora.
page 36.
30.
36.
Serial number?
Serial number 3, my lord. Rashmi Ranjan Bora.
Huh? Page?
Rosh- Page 36, my lord.
This happened on 11/1.
Respondent number 3, my lord. Serial number 3, Roshmi Ranjan Bora, my lord. He has completed only 4 years, 3 months, 9 days. Page 36, my lord. Respondent number 4.
Eligibility criteria as on the date of last date of submission. What is the last date of submission? 2012.
Yes.
So 2012, all these four did not have the eligibility of 5 years. That's your case. Yes, what do you have to say? Admittedly,
My lord, that is on record.
on record. You have no case there. We have to set aside those. What do you have to say? Were you appointed earlier?
My lord.
Were
Well,
you
as per-
appointed earlier?
My lord, as per order dated 22/5/2025, your lordship directed the private respondent also to file affidavit. My lord. As
Then
of today, we did not receive any affidavit.
you have filed affidavit? You have been given copy?
My lord, in this case also direction is there.
The earlier case, okay. I'm asking you in this case, are you appearing? Where did you complete 5 years? These were all grade 3.
Grade 2, my lord. No, my lord, my humble submission before your lordship, either in grade 3 or in grade 2. In either of the category, they have not completed 5 years.
No, these people were selected as grade 3. Then
Total, they want to say total. Total is not allowed. Total is not allowed. It is not and, it is or.
okay, no, that is what I have been dealing with it.
Yes,
Na?
my lord. Yes, my lord.
Why you have not filed the affidavit here?
No.
Which it is there. Are you a party there?
Possibly, my lord, in Roy Chaudhary's case, my lord, they are not party.
Huh?
In Roy Chaudhary's case, possibly they are not party. My private respondents.
Then they are grade 3. Na? They were. You are party out there. How?
Or 17 were party.
Selected candidates were.
In that case, all right.
Huh?
All 17 selected candidates were made party in my.
All. Where they filed.
So, my lord, whether my query is answered or not, my lord, I do not know.
Your
That
answer,
affidavit is not sought from me.
all your answer I will give you.
Yes, ma'am.
Hearing complete judgment reserved. We'll give it after vacation.
I'm breathing
Applause, my lord.
space for 15 days.
Huh? You can file it. I would have given it, but we don't have the time today. 2 days.
My lord, may I pray that one copy may be supplied to us?
What?
Affidavit.
Oh, did you? Give it. He also should have the satisfaction.
Right.
Heard Mr. P.K. Roy Chaudhary, the learned counsel, and P.K. Roy Chaudhary, Mr. M.A. Sheikh, and Mr. L. Mohan, the learned counsel appearing on behalf of the petitioners in the 3 writ petitions. And Mr. H.K. Das, the learned standing counsel of the Guwahati High Court, as well as Mr. S. Das, Mr. H.K. Das, the learned counsel, submitted that the stand taken in the affidavit in opposition in WPC number, first WPC would be treated as the stand taken in all other matters. Mr. Estas, who appears on behalf of the private respondents in WBC number 8, also appears on behalf of the private respondents in WBC number 2nd Connaught, and submits that the affidavit so filed in the said writ petition, in the first writ petition, be it also treated as the stand taken in the second writ petition, in WBC number so and so. Taking into account that the matter have been heard at length, judgment reserved. Why?
Instruction was not there. Practical instruction was not there to my friend.
My lord, my case is against 17.
No, you are not there in that case. Now, how will you know
Not-
that?
Not that case, my lord, but in the select list, my lord, if 17 goes, my lord, then I will get position. Marking is there, no, my lord. In the interview, that is stenographer test. On test, my lord, if 17 goes, my lord, I will be in position. I am only one petitioner, my lord. I am only one petitioner. If somebody is pushed, somebody is deleted from the select list, I will get position. That is my case. And I say that 4 persons will go from the selection. 4 persons are not eligible. If 4 person goes, my lord, I will get 1 and another 3 posts will remain vacant.
And he will also come in.
Who, my lord? I do not know, my lord, mark, as per mark, I do not know. As per mark, I will come.
How much? What is your serial number?
40 point something. 44, 47.
My lord, I got 46, but only point is necessary. Difference of point,
You have gone for revaluation.
difference of point. I got 46, my lord. I got
Chalo.
46.
We'll finish. Huh?
My lord, respondent number, I am giving, my lord. Respondent number 3, my lord. Respondent number 3 got 46.78. And I got, my lord, 46.69. So 0.09 is the question. 0.09 is the question, and respondent number 3 is selected. I was not selected. But he did not complete the criteria. Only 0.09. But whether she was selected, giving goodbye to the advertisement. That's my case.
We will not
Oblige,
be
Your
into con- Yes, his case, very important case.
We are really waiting. About the small person, my lord, really, my lord, what happened yesterday, I just came to know he could not pay the fees even for higher secondary for his child, my lord.
Huh?
Because of stoppage of payment, my lord. Now, higher secondary examination, his child is now going to be appear, my lord, the fees even he could not pay. And my lord, this kind of termination, my lord, totally against the Upendra's case, my lord. Page 22.
Mr. Busho, did you terminate after my order being passed?
Yes.
Huh? What? Understood, all understood. Did not get the payment is understood, but did you release him after my passing of the order? We will construe that action of the member motor accidents claim tribunal as an action taken interfering with the cause of justice. Why not criminal contempt being initiated against this member? Yeah.
No, my lord, there, Gaurav Babu said.
Let me submit.
I am not on that. He has not served whom notice? You. You have not taken steps? Anyways.
Class, my lord, it is intimated to.
No, I'm not on that, but my question is,
No, but it's not correct, my lord. Gaurav Babu said that because you have filed writ petition, now we will not in a position to continue. How could they know, my lord? If they, even there was a phone call, move from here. What is the hurry? Why hurry this kind of thing?
when I have no, when I have issued a notice in your presence, Mr. Bosho, I would not say much. I'm taking up the matter again on 17th. I would not say, I think better off you recall that order. Tell the officer. Otherwise, I may take action. If I have to issue notice, I will issue notice in this case. But if this is so, that if this allegation is a bit true, then obviously it amounts to interference with the cause of justice. He has approached for this court for two reasons. One, that he should get this salary for which he was working. Secondly, he seeks a regularization. Although I have not given any importance to that. In fact, I would have finished up this matter. It is because of Mr. Samaria's thing, I fixed it on 17. The matter would have been finished up today. I would have asked that why the payment has not been come. The payment has not come on the ground that there was a ban. Now the ban is over. Ban is over. Then what was the necessity of releasing him? Give me a good reason why. He was not released till that date because of the filing of the case. Absolutely. But Mr. Bosho, I am going to take up this matter tomorrow. I want this order, but tomorrow at 2 I will take it. I don't want to issue notice in this. Some mistake, no mistake, that is how you do it. You do it. If I issue notice in this matter, it will have a very serious consequences upon this because it doesn't inspire the confidence of this. You cannot do this. Your basic reason for not paying is that there was a ban. Now ban is lifted. There was a ban is lifted. So therefore the question does not arise. So he should be getting his salary, whatever may be. What was the good reason that you had to remove him after the notice had been issued? He had been all along working. Then list the matter tomorrow at 2. Economic writ petition. Economic Khali he will withdraw tomorrow after you recall. The judicial officers have to be more careful. And when that too, when I am taking up notice.
But notice, as per our clear information, my lord, they knew it well.
It's all because of your mistake. No, Mr. Samaria, it is absolutely your mistake. This matter would have been disposed of today. Unnecessary submissions you made, that is why the matter got to the on 17th. It was not necessary. I wanted to finish it off today, and therefore I asked them to only get the instruction. The ban is over, you would have got that money. Matter would have been over. Unnecessary because of you, this person has got the area. But Mr. Boyso, kindly communicate and show him whatever video is required to be shown. He will understand.
Okay.
Here are direction to take steps by justice service, Lordship. We have taken the steps and affidavit is filed, Lordship, today.
এইটো কিবা চিৰিজ আছে নেকি এইটোত? When have I fixed the 111 CRP? এইখন কেতিয়া ফিক্স কৰিছো 111 CRP খন? CRP 111 খন যে আছে। Service affected?
Yes, Lordship, by dusty mode, Lordship.
গম পাইছে কোনটো কেছ? সেই চিৰিজটো লৈছো যে। আজি নহয় নহয়। গম পাইছে না এইটো মটৰ ভেহিকেলৰ 111। Ah. 111 I have fixed it when? 22nd if I am not wrong. Yeah, 22nd. Right? 111 CRPIO 111 of 2024. Isn't it the connected matter? List this matter along with CRPIO 111/2024 on 22nd of July 2025. First, this court have also taken note that the service have already been effected by way of dusty routed through the registry of this court upon the respondent number 1. First, list the matter. List the matter along with it. First, the interim order passed earlier shall continue till then. Mr. Saikia, what I am going to pass order on 22nd, just think about it because you are also a counsel in this type of matter. Other Mr. Kolita is appearing. That I will direct the Motor Accidents Claims Tribunal or wherever the matters are fixed. Whenever application is filed beyond 6 months, the Motor Accidents Claims Tribunal shall ask the officer in charge where the accident had taken place. As regards any FIR has been filed and whether the FAR, DAR, R or DAR have been submitted. If not, directing them to submit. Once that the DAR is being submitted, then this petition shall be tagged along with the MSC case shall be tagged along with the DAR and proceeded. This is how one has to implement the Gohar Mohammed's case because there was a direction, specific direction. So this is what I am proposing. Think about it, whether that will be proper. Because otherwise, at one as very important aspect is these people's right is there. And therefore, it has been conceived of it is not required to file a claim petition. Actually, that is the basic idea. That you don't even need to file a claim petition. You want to give additional pleadings, you can very well give it. But you want to file it, you can very well file it also, taking into account your convenience. Therefore, in Gohar Mohammed also says that if I file the claim petition in Guwahati and the DAR is in Tinsukia, the DAR proceedings will come. This is how it is there. But if a person has not filed it within that time, then the MSC case will be registered and kept out there. And in the meantime, the court will ask the officer in charge to submit this. And the officer in charge thereupon shall submit this and then the court shall proceed. This appears to be the best way out. And then in the meantime, I'm asking them to issue some notifications in the other matter, directing the Home Department as well as the Transport Department to issue appropriate notifications, which they are going to pass. Once they pass that, then it becomes binding upon those police officers also to do that, whereby the police officers will send you the immediately upon that, when they come that there is an insurance out there. So this will be intimated to you within 2 days or 3 days, they have to do it. No? So So they have to do it. And the charge sheet having been submitted. Think about it. I think this appears to be the only way. Then you may come up with a better solution.
As per the last order, service is complete by way of Dusty.
Service?
Service is complete by way of Dusty, my lord, for respondents 1, 2, and 3, and the affidavit of service has also been filed.
Respondents one.
Now she wants to produce some documents. You are appearing for? Bank? Okay, you have filed your reply. Okay, Mr. N. Burwa, the learned counsel, appears on behalf of the respondent number 1, 2, and 3. And he submits that there are certain allegations made in the instant application which requires to be controverted. Taking into account the above, list this matter on 11th of August 2025. The reply to the instant application being filed be filed by 4th of August 2025. Liberty thereupon shall be given to, is also given to the petitioners to file any reply thereupon. Rejoinder date.